Madam, pardon to mention, this is fresh item of the income tax matter. I have challenged the order passed under section 263 by the principal CIT and violation of the mandates of the structure as well as the principle of natural justice. Unless the matter is taken up, the CIT has one appointment matter. Another matter is neither it was in the list, but it was subsequently delisted. Income tax matter.
Yes, matter. Yes.
I got the habeas corpus application, the 16-year-old has been tendered by the opposite parties. But on the last occasion, the case was directed to seek rescue of the girl. The matter could not be listed.
My lord, pardon to mention, my lord. Pardon to mention, this matter relating to tender matter, challenging the conditions of tender. Yesterday, it was in the list, my lord, because my lord Justice K.R. Mahapatra and just my lord Justice Sanjay Kumar Mishra recused himself from the, as he was the counsellor of the.
It has already assigned. Don't worry about it.
My lord, tomorrow is the last date for.
It has already been assigned. It will be listed. Don't worry.
My lord,
It has been assigned. You don't understand.
It has already been given to a bench. So it will be listed.
Matter is urgent, my lord.
Tomorrow
Just keep it.
May I pardon one?
And state government has come up with a report showing the steps taken to remove unauthorized persons from government hospital premises or alluring the patients to private hospitals. The report has already come and matter was supposed to be listed on 26th March. It is not listed on it.
May I pardon? Fair matter. Yes, it was challenging the confiscation proceeding matter. May I pardon?
Give the slip, sir.
May I pardon one minute? Jealous act matter.
JLS Act is before this bench. Go and see the assignment.
Pardon to mention, your lordship, two matters, WPC 6067 and 5909 were tagged and listed together for 4th of April, your lordship. Lordship, in both the matters, notice were issued. Lordship, order was only updated for one of the matter, your lordship, and not for other.
Next week.
Of like face admission, read up in matter.
Give.
Face
Matter. Face content.
Face admission matter.
Yes, income tax matter will. My bank account was seized by the income tax department without.
All right, next week.
Yes, GST matter, man.
Next
Fresh matter.
Give the fresh matters. Give the fresh matter.
next week.
Review matter.
No tomorrow.
My lord, it's item 8 permitted to withdraw.
Oh, by all means, welcome.
Item 1A.
No, only 8.
8, yes. Who is for the other side?
It's a fresh matter, my lord.
Fresh matters.
Your name?
Uncle Kumar Dibedi.
SK Mr. Judah.
Yes.
Item 39, I pray for one week time. I have already informed my learned friend, other side, Mr. Sunil Visconti. I pray for.
Where is the other side?
I have already informed Mr. Mishra for the release.
Is there?
Only information, no consent I have given.
Oh, then he is opposing.
He has to hand it over me
Some
the additional affidavit.
Documents
also
are
there is
required to be
Let it
collected.
reach.
Madam,
Let it reach.
I don't 28 million. 28 on behalf of Rudana Mahapatra. His mother is dead.
Yes.
Since I pray the matter.
List on. 8. Seventh, 8th May.
Please pardon, madam. Item 29. I pray 2 weeks time to file counter. While
Item?
Item 29. I am sorry, it's not.
So call number?
Number 1 and 2.
1 and 2, 6 time to file counter. List 13th May. Interim order.
Great.
Serial number 22, 6 2 time, my lord. I am for the opposite party. I have taken consent of the petition.
Is present?
Yes, yes.
Mr. Mishra has telephoned me as a gallbladder. So it is first week of May or second week of May?
On like 13th May, has prayed by the opposite parties.
Well,
Private opposite parties.
public.
Give.
I beg pardon to mention. Maybe pardon to make a mention, rate of me has been prepared by state government. I am.
What do you
I am
want?
for the respondent.
You want it, listing,
Any date for.
give the number.
Yes, admission.
Over the Gramya Jungle property. Now, the record shows that a counter FIR has been lodged by the alleged respondents, private respondents against the petitioner.
What for?
Who was
Because
the
of
petitioner?
theft and the breaking of
I am
the.
for the petitioners, I am for the petitioners, Lordship. This case was last occasion state was directed to obtain instructions.
Day after tomorrow.
That is between them. That's a private
Yes.
dispute between them.
Yes.
The law will take its own course. If they have lodged a FIR, then definitely investigation would be there.
Yes.
But suppose if there is a garment
Unauthorized
and the
construction.
encroachment is unauthorized, then it is your primary duty
Well,
to
they
take care.
are providing the instructions today, my lord. I pray this matter may be taken up day after tomorrow.
Next week.
Only day.
After tomorrow, next week.
Next week.
15th as paid by Mr. Das and Council and the G.
Item number 2.
Oblige, Lordship.
May it please, my lords. Lordships, I beg to appear virtually, my lords, for the petitioner, my lords. Lordships, my
Why
lords,
you people are using the word big?
my lords, my lords,
You have every right to represent your client.
I'm grateful, my lords. I'm grateful. My lords, the issue, my lords, involved in this petition is, my lords, when GST was introduced in July 2017, my lords, the law provided that if there is any tax paid under the erstwhile laws, my lords, which is available as a credit, then that can be transitioned, my lords, into the GST regime. Now, my lords, I am, my lords, a contractor, my lords, which was performing contracts for the central government and state government in the state of Odisha. My lords, the Odisha VAT Act provides, my lords, when the contractee has to make a payment to me, he has to deduct a TDS. That TDS was deducted, my lords, and that TDS is available, my lords, to me as a credit, which can be adjusted, my lords, against my future liability. Now, my lords, as on June 17, I had a TDS of around 10 odd crores, my lords. Now, my lords, the section 140 subsection 1 of the Odisha GST Act clearly provided that this was available as a credit to be transitioned, or in the alternative,
It was available as a credit.
as a credit, my lords, which could have been transitioned, my lords, in the GST regime. So, my lords, it was available in my return. I transitioned it. Now, my lords, I received a show cause notice, my lords, by the Odisha GST authorities under a section called Section 73, my lords, which, my lords, my submission is that that section per se is not invocable because, my lords, that section can only be invoked when there is a short payment of tax or, my lords, a wrongful availment of an input tax credit under the GST regime. Nonetheless, my lords, I received a show cause, I took jurisdictional objections, and I clearly mentioned that the issue now is no longer res integra. 3 high courts have decided it. Ultimately, either this is available as a refund or it has to be transitioned. And the Supreme Court, my lords, now has said that this is a vested right. And ultimately, this is under Article 300A an asset, and it cannot be, my lords, now not be, my lords, diminished because this is ultimately tax. Now, my lords, the order was adjudicated, and my lords will see, my lords, the reasons of the order with respect, my lords, are first of all not addressed to me. A detailed reply has been filed by me, my lords. By virtue of one line, it says that no, this reply is considered, and there is nothing which is valid.
Which page?
My lords, there is a memo, my lords, which I have filed, my lords, and in the memo, your lordships will see the reasons appear, my lords, at page 42A.
Where is the memo?
See, that's not, that's.
Let's see.
The lordships will have the memo, my lords, 42A, and my lords may have, my lords, the brief facts, my lords. The first line, my lords, the name of the party is something else, my lords. I am East Coast, but it says this is an order of adjudication in the case of Manoj Mishra, Kumar Das, which, my lords, is not me. Then, my lords, after
it is a East Coast Constructions and Industries Limited.
That's correct, my lords. That's the petitioner herein. But, my lord, see the operative part, which is just below the brief facts of the case, that your lordships will find, my lords, that it says this is an order in the case of Messrs. Manoj Kumar Das. And then, my lords, the facts after 4 lines is that it is engaged in granulate.
No, I'm unable to reach to this, what you are saying, sir. I'm unable to find out what you are saying.
I'm sorry, my lords. My lords,
Yes, I have seen brief facts.
and my lords, the first line I will read, my lord. It says, this is an first line, my
This
lords.
is an order of such and such.
In the case,
Proprietor Mrs.
Raj Enterprises.
Yes.
So your case is that this order does not relate to you.
But my lords, I'm giving them the benefit of doubt that perhaps, my lords, because the name in the subject matter is in my name, but my lords, assuming that, my lords, this is a typo. But my lord, further, if your lordships will see 4 lines below, it says you are dealing in granulated slag from the manufacture of iron or steel. Just 3 lines below. That is also not something that I
copy paste.
That mistake of copy paste. my lord.
Except that first paragraph, all others are relating to this petition.
So there's a non-application of mine, sir. It is absolutely a non-application of mine. That means a copy paste or a cut paste is a dangerous adjudication.
Yeah, let's see all of the paragraphs.
But whatever, that means that there was non-application. It was not a proper application of mine.
First paragraph is copy pasted.
That is what it shows, that it is really wrong.
And my lords,
Is there any limitation for that?
Your Lordship, this is for the 17-18, 5 years from 2020, 2025 years, February 2025, Your Lordship.
Is a limitation.
Your Lordship.
And when it is issued?
This order has been issued, Your Lordship, on dated 30th December 2023. 23. After 4 months, after lapse of limitation period, this rate has been filed.
There is a provision for an appeal.
Your Lordship, it is appealable
Where?
under section 107, Your Lordship.
May I just submit, my lords?
Before
first appellate authority.
is it still there, functional?
Your Lordship.
And what is the limitation?
Limitation is 3+1. 3 more.
My lords, with respect, my lords, my case is, my lords,
They have not gone there.
Not gone there.
my lords, the order is without
And
jurisdiction.
when the writ is filed,
This writ petition has been filed, Your Lordship, filed in number. In July, the number has been made. Your Lordship,
Because in 2024, I filed, my lords, the matter could not be listed, my lords.
19/6/24.
Your Lordship.
this is the 20th. Oh, sorry.
14th May.
After the period of limitation for appeal.
Your Lordship. 4 months, Your Lordship, this order has been passed and issued, Your Lordship, on dated 30th December 2023. 30th
December
30th December
2023, then it's April 2024.
Your Lordship. Much after, Your Lordship. 1 year ago. No, 2024 it has been filed.
December.
After 5 months. No, this petition has been filed.
18 June.
It means after 4 months.
Your Lordship.
Obviously after 4
Your
months.
Lordship, after 4 months.
My lords, may I just submit, my
Your
lords?
Lordship, as per the settle law 1
There are no disputed
Yes.
facts.
Your Lordship knows very well that.
My lords, there are no disputed facts here, my lords. My lords only argued before the authority.
Sir, the point which you are now raising could have been raised before the appellate authority.
My lords, I
Now
did.
the position is that you have filed, but now by this time, if we say that it was clearly a mistake, now there is a limitation period that they cannot reopen it after a gap of 5 years. So you get the unnecessarily advantage of it.
My lords, I don't want to take that advantage, my lords. I'm saying, assuming, my lords.
Can you dispense with the limitation?
My lords, my lords, I have no difficulty, my lords, but I have got a better point. My lords, all I wanted to point it out, my lords, through this, my lords, passage was that there is non-application of void. But what I'm going to submit before my lords is, my lords, that I have filed a detailed reply to the show cause notice. In the show cause notice, my lords, I said 2 things, my lords. One, my lords, I said that this section itself per se is not invocable. Secondly, my lords, I said that the provision has been interpreted with respect to, my lords, the same act, my lords, under, my lords, the Calcutta, my lords, GST Act and also Jharkhand GST Act. The High Courts have taken a view that 73 is not invocable. Plus, my lords, this amount, my lords, is now, my lords, an indefeasible right and it is available as a credit. Alternatively, if it is not available.
You are saying that Supreme Court has said that this is now a property within the meaning of Article 300 capital A of the
Correct, my lords. Specifically, my lords. So therefore,
we have to go through it, whether it can be said to be a indivisible right, the right to a property. These are all the things we have to consider.
Your Lordship,
Please, my lords.
on maybe Your Lordship, but my learning friend is agree. I can ask the question, Your Lordship, on basing on the law, Your Lordship, legal aspect, how it is not admissible. Your Lordship, for a moment, Your Lordship, shall I?
So let him, actually, that is his right to begin life with him.
Your Lordship, Your Lordship.
So show us the judgment. Show us the judgment. That what are the judgments you have?
My lords, I will show that. My lords, just may
Your Lordship may go through the fact, Your Lordship, because the judgments are different, because the estoil acts are different. The estoil, it arose from the estoil act. Your Lordship, the judgment may be different, Your Lordship. Whether it is admissible, TDS is admissible. He has admitted it is TDS. So whether TDS is admissible to be a credit and transferred as a transitional credit in the GST Act.
This is what he said,
That
that the Calcutta High Court has said yes. He has said the other high courts have said yes. Even a Supreme Court says that it is a property.
Right.
So let us hear, let us see that what is this.
Your Lordship, right.
Now, my lords, your lordships may, my lords, first have, my lords, the judgment, my lords, of the Jharkhand High Court, my lords, which your lordships will find, my lords. This is, my lords, Subhash Singh Chaudhary, my lords.
Yes, that's the Usha Martin case.
My lords are at Usha Martin, my lords, very well, my lords. Then my lordships may have Usha Martin, my lords, and lordships may straight away come, my lords, at para 15. One
of which?
My lords, your lordships are at Usha Martin, my lords.
No, the both. Yeah. Usha Martin is also with us.
Very well, my lords. My lords, we first have Usha Martin. My lords, I want to just show, my lords, that this is a jurisdictional issue, my lords.
Please,
and my lords,
please.
My lords, may kindly have, my lords, para 15, 1-5, my lords.
Yes.
And my lords, I'm very sorry, my lords, before para 15, kindly have para 13. I'm sorry, my lords, para 13. And para 13, if I may read, my lords. We have considered the submission of the parties. We have
the most longish paragraph, 13.
I will just read out, my lords, the relevant lines, my lords. The fourth line of para 13, my lords, which starts, my lords, from the line.
We have also examined the relevant provision of the CGST Act.
Correct, my lords. And my lords will see, my lords, from the chronology of facts borne from the pleadings on record, it is not in dispute that the impugned order in original has been passed under 73 subsection 9. That is my case also, my lords. And it relates to availment of SENVAT credit. My case is of VAT credit, my lords, which was allegedly inadmissible under the Central Excise Act and the Finance Act. It is also not in dispute that no show cause notice or order in original has been passed under the existing law. That is the Central Excise Act or the Finance Act read with the SENVAT credit rules, either at the time of filing the Tran 1 or thereafter. The writ petition has been preferred purely on a question of legality and jurisdiction of the respondent number 1 to initiate proceedings under 73(1) of the CGST Act for transition of SENVAT credit, which was allegedly inadmissible under Central Excise Act read with the CCR Act. The issue herein does not require entering into any disputed questions of fact. The primary issue relates to the jurisdiction of the respondent number 1 to initiate proceedings under the CGST Act. In this regard, my lords, the latest judgment of Maghat Sugar of, my lords, the Supreme Court, my lords, is extracted. It says, my lords, where jurisdiction, etc. is involved. My lords, I will not read that part. And my lords now may have the operative part, my lords, which is at para 15. My lords, it says, my lords, from the conspectus of the facts borne from record, two questions emerge in the writ. One, whether the initiation of proceedings under 73(1) were within jurisdiction of respondent number 1. And secondly, in view of 174 of the CGST Act, such proceedings for availment of alleged inadmissible SENVAT credit could have been initiated under the old law of the Central Excise Act and the Finance Act. And, my lords, then they extract the sections. With respect, my lords, the sections under this Act and, my lords, Orissa GST Act are pari materia, my lords. And thereafter, my lords, your lordships, the conclusion is provided, my lords, in para 19, just above para 19, my lords. My lords, may have para 19, just the para above para 19. It says a perusal, if my lords has that. A perusal of 73 makes it clear.
Para 19.
My lords, para 19 just above para 19, the para, my lords, which starts with the words a perusal.
Yes.
My lords has that, my lords.
Yes.
A perusal of the provisions of 73 makes it clear that such a proceeding can be initiated for non-payment of any tax or short payment of such tax or erroneous refund of such tax or wrongly availing or utilizing the input tax credit. Section 73 does not speak of SENVAT credit. My lords, my case is of VAT credit, it's same, and does not provide for SENVAT credit. Rather, the term has been subsumed in the expression input tax credit, both relating to supply of goods. The assumption of jurisdiction by the respondent number 1 to determine whether SENVAT credit was admissible under the existing law by invoking 73 was therefore not proper. So, my lords, my first submission is, my lords, that the notice is issued under 73. 73, my lords, gives a power to the officer to issue notices for inadmissible GST credit under the GST law. And, my lords, any proceedings which are for the erstwhile law, and, my lords, this judgment addresses that. It is not that the revenue is remediless. It categorically states the proceedings should have been taken under the old law, which, my lords, will find, my lords, at para 22. So they are saying the revenue is not remediless. They ought to have taken the path under the old law. Para 22, it says, therefore, it is clear the repeal of the existing laws upon coming of the GST regime did not leave a vacuum as to the past transactions which were not closed. The repeal and saving clause E of 174 of the CGST Act allowed such legal proceedings to be instituted in respect of inchoate rights, except rights under transactions which were past and closed. Petitioners also admit that the proceedings for availing SENVAT credit, which were allegedly inadmissible under the Finance Act, read with the CCR rules, could have been initiated under the existing laws. It is also not in dispute that in respect of previous proceedings for such contravention, the cases have been kept in the call book, and some of them the learned sestat has stayed recovery. The duty of constitutional courts is to interpret the law and also to ensure that there is certainty about the law, not only in the minds of law enforcement agencies, but also in common persons. If the proceedings for transition of SENVAT credit alleged to be inadmissible is permitted to be carried under the CGST Act, it may lead to uncertainty, not only in the minds of the ordinary citizens, but also of the tax authorities. In some cases, a jurisdictional proper officer under CGST Act may initiate proceedings under the provisions of CGST Act.
I understand that whatever has been done, if there is any violation, that
they have to proceed under the
violation. That violation was under the earlier acts.
Please, Lords.
Therefore, there is no impediment on the part of the authorities to initiate a proceeding under that act, as if it has not been repealed, and therefore, the exercise of jurisdiction under the new regime or the new act for the offence or the violation having committed under the repealed act, that is beyond jurisdiction and not permissible.
Malas, I'm grateful. Therefore, my lords, I'm invoking, my lords.
But what has happened thereafter?
My lords, kindly see thereafter, my lords. Jharkhand High Court, my lords, the same, which is the second judgment, the same issue, which is, my lords, identical in our facts arose. And, my lords, the Jharkhand High Court, in fact, my lords, very categorically states that VAT credit is also admissible. Kindly have para 12, where the findings start. And your lordships will see an extract of 140 subsection 1 of the Jharkhand Act. Paragraph 12, my lords, running page 10. My lords have para 12, your lordships. And, my lords, in para 12, my lords will see, my lords, that there is an extract of section 140 subsection 1. And, my lords, this is, my lords, a pari provision to Odisha. And, my lords, may I read subsection 1? It says, a registered person shall be entitled to take in his electronic credit ledger credit of the amount of value-added tax. My lords, this is the provision that if there is any value-added tax, I am allowed to transition it. The department's case is, my lords, that look, this is not input tax credit, this is TDS. But your lordships are aware, my lords, even under income tax, my lords, if I make a payment, my lords, to a professional, I have to deduct, my lords, TDS, and that certificate is issued, my lords, in favor of the assessee, and the assessee takes it as a credit. So, my lords, that is in effect a VAT. So, my lords, this was the question, and my lords, lordships may kindly see the analysis, my lords, which your lordships will find at para 14, running page, my lords, 18. Matlab in the middle, my lords. Admittedly, it says admittedly under JVAT Act, even
Para 14.
Matlab para 14, your lordships.
Yes.
Last line.
Yes, yes.
So it says
Immediately under the JVAT,
JV Act, even entry tax was levied under 11, and the said levy of entry tax was availed as input tax credit for adjustment against output tax. TDS amount was also available for adjustment against output tax liability, apart from input tax credit, which is available for adjustment. So, my lord, the court says one is the credit, my lords, which I receive on the purchases, which is input tax credit. In addition, there is a TDS which is available. And then, my lords, kindly see, my lords, the para after this para, which starts with the words the legislature. It says the legislature in its wisdom even provided for migration of unadjusted entry tax under the GST regime, as otherwise the said amount would have been refundable to the assessee in terms of section 52. So, my lords, there was either a refund or a credit. And then, my lords, para 15, just 3 lines above, it says this was to avoid the cumbersome process of asking the assessee to claim refund. Because, my lords, if I would have gone to the state, they had to give this to me in cash along with interest. So they said it's easier to take a transition. This was avoid to cumbersome process of asking assessee to claim a refund of unadjusted TDS, entry tax, input tax credit, instead to allow the assessee to migrate it. And now, my lords, kindly see the relevant part, my lords, which is, my lords, at para 18, my lords. It says, my lords, apart from the above, we cannot ignore the fact that unadjusted TDS amount would have been otherwise refundable to the petitioners if the same were not allowed to be carried forward as excess input tax credit in the statutory format. We have examined the format wherein so-and-so unadjusted credit amount has been treated as input tax credit amount and was required to be carried forward in the succeeding months. The petitioners at the time of filing their returns were left with no option but to forward the unadjusted TDS amount as excess input tax credit in the succeeding months and were not required or compelled to claim refund. Thus, at this stage, the respondents cannot contend that the unadjusted TDS amount cannot be allowed to be migrated in terms of 140 subsection 1. Even otherwise, the stand of the respondents is self-destructive.
Provided it is in excess.
It's in excess. Now, my lords, for me, my lords, in my case, my lords, even it's the department's case that this TDS is lying, my lords, to my credit, and I could not have used it as on 30th June 2017. So therefore, my lords, when 1st July 17, the new regime kicked in, I transitioned it. And my lords may see, I filed a reply, a detailed reply, my lords, bringing all of this on record. My lords may have my writ petition, my lords. I will point out these judgments given, and even, my lords, given, my lords, the undisputed facts. My lords, lordships may have running page 169. This is, my lords, my detailed reply, my lords. This running page 169, my lords.
169.
169, my lords. This is, my lords, the reply to the show cause notice. This is, my lords, annexure 9, a reply dated 14th March 2023, a detailed reply, my lords.
Yes.
Which has not been considered. My lords may have para 8.2. It says, my lords, this is second line. In terms of section 54 of the Odisha VAT Act, government local authorities established by or under a statute or any other association should deduct TDS from the payments made to the contractor for execution of works contract and remit tax to the government account in name of the contractor. This is what has happened in my case. Accordingly, all payments released to the notices by the government departments towards works contract executed by them during the VAT regime were subjected to TDS, and the notices were issued certificates for the same. Since there was no output VAT payable by the notices during the period prior to the introduction of GST, all TDS amount deducted and paid by the government department in favor was accumulated. The same was carried forward in the VAT return, column 56, and I'll show that column, my lords. At the time of introduction, the noticee had accumulated excess payment of TDS of 10.67 crores, which was refundable. And my lords, kindly see the section of the Odisha GST Act, pari materia to Jharkhand. And I will just read the first line of 140 subsection 1. A registered person shall be entitled to take in his electronic credit ledger credit of the amount of value added tax. So, my lords, I say that, my lords, and then my lords, lordship may see para 8.6. My lords, I submitted that the notices submit that under VAT regime, tax was paid on the following basis, either by utilizing input tax credit, which is on purchases, my lord. Second, adjustment of TDS deducted. And third is in cash for the balance after setting off ITC and TDS amount. Therefore, since the tax paid under VAT Act is included in all the aforesaid components, the legislature in its wisdom deliberately used the term credit of the amount of value added tax. And my lords, thereafter, my lords, your lordship will see para 8.8, where I clearly say, my lords, the notice submits that the denial of carry forward of unadjusted TDS from VAT to GST regime would have made the government to refund the excess tax credit lying with them to similarly placed assessees like the notices.
This is what Kunal Synergies Limited, the judgment has said.
Well, this is what the judgment.
Refund with 9%.
Correct, my lords. And my lords, kindly see para 8.11. I extract all of these judgments. Kunal Synergies, my lords, is the Calcutta High Court, follows Usha Martin and states the same. And kindly see para 8.12. I also give this Jharkhand High Court, which I have placed before my lords. Para 8.12 at running page 175.
Yes.
I give this judgment also, my lords. And my lords, then, my lords, your lordships, kindly see specifically on jurisdiction also, my lords. I want to just show that para, which is at page 184, para 11.8.
Yes.
I say don't invoke 73.1 also. And my lords, kindly see what are the reasons in the order, my lords. Your lordships may come back to the memo. This detailed reply given, and my lords, there is just one line in 42C of the memo. My lords, my lords, there is a table, before the table, 2 paras, and there is a line. The reply submitted by you is verified and is not satisfactory. This is, my lords, the only reason given. In 42C, my lords, the first para, last line.
Which one?
My lords, if you lordships will see the memo, my lords, which has the reasons of the order, after giving this detailed reply, my lords,
page.
My lords, it's the memo, page 42C. It's a 5-page memo. It starts with page 42A, which my lords had seen has the title A. And my lords may come to 42C.
C or D, what?
42C, my lords. 42C.
Yes.
Para, last line, is the only finding. The reply submitted by you is verified and found that it is not satisfactory.
No, I could not get it. Sorry.
Last slide, sir.
42C.
42C, I'm at.
First para, last line.
Oh, this. The way of placing is so cumbersome. Anyhow.
This is, my lords, the only reason, my lords.
Just say that the last sentence of the first paragraph of the same page.
Apologies, my lords.
So one can go straight away to that.
Please, my lords.
Just line above the paragraph. I am not accustomed with these kind of a system.
I'm sorry. I ought to have, my lords. I should have said.
No, it has a paragraph. Say there's the first paragraph, last sentence.
Please, my lords. First paragraph, last sentence. This is the only, my lords, manner in which
That's only. That's also you say that it is a unreasoned order, non-application of mine.
Non-application of mine, and therefore,
you have not considered all those judgments which have been placed.
And also, my lords, my jurisdictional objection, which is that per se this section cannot be invoked. Even that is not considered, my lords. Which your lordships have seen shown, my lords, under Usha Martin, that my lords 73 cannot be invoked. They ought to have, if they wanted to deny, my lords, because my lords, the facts are not in dispute.
They could have initiated proceeding under the repealed act.
Please, my lords, because there is no difficulty. There is a saving provision under section 174, which says any action taken under the earlier acts, you initiate proceedings under those acts. And my lords, I am not disputing that. If my lords, they want to do that, they can do it. But my lords, this credit is actually my money, my lords, and it has been deposited to their credit. They have certificates which I have given. My lords may see annexure 2 are my certificates which I have given to them. I have placed my returns on record. My lords may see annexure 2, page 43. Yes. All my certificates are on record, where I clearly say that, look, these are government agencies who have paid me money, deducted TDS. Then I give my returns and I say that I have shown it in the return. I put you to notice. You could have verified this.
Yes.
And my lords, they don't even verify. And now my lords, if this, my lords, is admissible to me, my lords, if it is not provided to me, my lords, the courts have held this is violation of Article 14, my lords, and also 300A. Because, my lords, even if it is conditional, the conditions were that I had to show it in the return, which I have done. So, my lords, it's a right, my lords, which cannot be defeated in this purpose. Plus, my lords, the proceedings, root and branch are illegal, my lords. Therefore, my lords, I'm praying, my lords, may kindly stay, my lords, this. I have received also, my lords, subsequent letters, my lords, which I have placed on record by way of a separate IA. They've been issuing recovery notices to me, my lords, which, my lords, even though the money is lying to their credit notes.
Yes.
Your Lordship, for the judgments are concerned, Your Lordship. I may be.
Mr. Mishra, kindly visualize the situations. There has been a judgment, and the judgments, they speak about this section 140, the transitional provisions. The judgment says that whatever the TDS which was deducted under the VAT regime or a SENVAT credit, as you know, which was available to him, if those are still available and in access, then in that event, these judgments says, one judgment says that refund, one judgment says that you can carry forward, and therefore you can take an adjustment thereof. And then say the proceeding under this 73 is of some kind of a, the checks and balances. He raised all these questions and points in his reply. It was a very extensive reply. He has referred many pages. It appears that the authority has not taken into account even a single point. There is no difficulty on the part of an authority to decide its own jurisdiction and the competence. If somebody has raised that you lack jurisdiction, the authority is not denuded of power in deciding that. He can. But by one stroke of pen, if we discard everything not satisfactory, is it an adjudication? Maybe an administrative or it's the administrative field, but he has to. So if there is no assignment of a reason, then what to do?
Your Lordship may set aside the matter with a time bound.
So we are remitting the matter. Let him decide after taking it, and then. The difficulty is, I tell you, we are conscious because we have to strike a balance between the rights of both the. If the SSC has a right, then the revenue interest should also be taken into consideration in those line of judgments of the Supreme Court in Income Tax Acts.
Your Lordship, I can establish, but it is not proper on my part to develop the order, Your Lordship. I can establish that TDS is not.
Whatever, then it's the authority. When everything has been placed, then it is the authority who has to decide it.
Your Lordship. Because under our S2 law, there is a provision for reform, and the procedure has been adopted, and the procedure is there.
Let him decide that. Let him decide that.
I should not.
Yes, we are remitting the matter to the authority to decide all the points.
Because of my
no objection to that, Manoj.
Yes.
No objection to that.
pray, Your Lordship, without any observation on merit here.
Just listen to the order which we are going to pass. Don't worry. Don't worry. The the order of the jurisdictional commissioner,
Your Lordship, this is the assessing officer.
assessing officer,
Assessing officer.
the order of the jurisdictional assessing officer dated
Your Lordship, 30th
30th December 2020.
30th December 2023 under section 73 of the OGST 2017 is the subject matter of challenge in the instant appeal, in the instant writ petition. Several issues have been raised by the petitioner, including the jurisdiction and the competence of the assessing officer exercising powers conferred under the OGST 2017 in relation to the tax deducted at source or the credit available to the SSE prior to coming in force of the OGST. Stop. It is vehemently contended by the emphasis is put to the provisions contained under section 140 of the OGST Act 2017 relating concerning the transitional provisions in support of the contentions that there is no fetter on the part of the authority to give credit available to the SSE prior to the coming in force of the OGST Act, and in fact have been decided by several high courts. Stop. It is contended that the extensive reply was given to a show cause notice issued under section 73, not only raising the facts relevant for the purpose of an adjudication, but also the nuances of the law as it stands. But the authorities have not taken into consideration the above aspect and simpliciter proceeded to discard the contention of the petitioner by a stroke of pen that it does not appear to be satisfactory. We have been taken to the different paragraphs of the said order. And find that the authorities have not returned any finding on the facts and the law, the issue of facts and the law raised in the said reply. Even there appears to be an error in the opening paragraph of the said order. So far as the facts are concerned, which lead to an inescapable conclusion that the authorities acted with a closed mind and in fact did not adjudicate the issues in a proper manner. Next. There is no independent finding returned by the authority both on facts and law. And there is no hesitation in our mind that the order is bereft of reasons. Stop. The importance of providing the reason both in administrative as well as the judicial field is well known and well recognized. Stop. Providing the reason not only assists the higher forum in deciding the issue and ascertaining the decision-making process. Stop. The writ jurisdiction exercised by the High Court does not overreach the correctness of the decision, but the decision-making process. Thus, the reason being the heart and soul of an order, if not provided by the authority, it would be a dead letter. Stop. We thus find that the authorities have shirked its responsibility in providing the reasons while adjudicating the issues raised before it, and therefore such order cannot be sustained. The order impugned in the instant writ petition is thus quashed and set aside. The authority is directed to reconsider the case afresh after providing any opportunity is provided.
Please, Manoj.
After providing an opportunity of hearing to the SSC and shall pass the final order by recording proper reasons in accordance with law.
And Manoj, also the jurisdiction.
It is expected that the authority will show some alacrity into an issue as the matter is pending since long, and the entire exercise is to be completed within 2 months from the date of the communication of the order.
It is only to court.
Stop. The SSC shall cooperate and assist with the assessing officer and shall not indulge in unnecessary adjournments unless necessitated by unforeseen and unavoidable circumstances. For abundant precaution, we made it clear that the observations made herein incidentally or accidentally, touching upon the merit of the respective parties shall not have any persuasive effect, and the authority shall decide the same independently without being influenced thereby. Anything more?
Observation of the jurisdiction, and even the jurisdiction.
All the points which are raised, we have already said you have raised the point of jurisdiction there.
Very well.
So he will consider.
And
Under section 73 only.
Let us see. Mr. Mishra's level of energy is much high. You have to meet that level of energy. Yes.
Consequent recovery letters, etc. will also be
yes.
sent. Very well.
That is a consequential order. If this order goes, then what remains? The order is passed and set aside.
Very well, Manoj.
So there is another appeal. So that appeal has to be decided. Another appeal against the recovery.
No, Manoj. The recovery, Manoj, is a consequent action pursuant to this impugned order.
No. Have you challenged the recovery order?
IA has been filed.
IA 4188.
In view of quashing and setting aside the impugned order,
It is obvious.
any action taken thereupon shall fall, and therefore the order best thereupon, if any pass, are also caused and set aside.
Very grateful.
This is obvious, this is automatic.
Obliged, my lords. I'm
When
very
the edifice has gone, then the superstructure will fall.
Yeah, obvious. Good.
grateful, my lords.
Item number 3.
May I please, Your Lordship?
Here there is the allegation of unauthorized construction. There is an allegation of unauthorized encroachment over the drain that is given for national highway. Now, my lord, pursuant to the letter received from the executive engineer, so also the order passed by this honorable court, last order, an inquiry has already been undertaken by the Tahsildar Mohan. I'll furnish the report. Your lordship may call it on Monday.
The report be filed. You were supposed to file it today.
They are conducting an inquiry, so your lordship, I'll furnish the report on Monday.
Tendency submits that he will find the inquiry has been conducted in terms of the earlier order dated 26/3/2025, and the report shall be submitted on the next date, list on 15th or 16th. 16th April.
Item number 4.
Item 4, where I have received instruction in the sake of Parawise comments, if your lordship will have it. Here the allegation was unauthorized construction over the endowed property. Unauthorized construction
Over a plot of land,
yes,
which according to them are used by the villagers for religious purposes.
that is the DT's property. That is the allegation of DT's property. Whereas I have received the instruction,
Is the public DT or is the private DT?
they have stated in the writ petition as it is an endowed property. But my instruction, it is not an endowed property, but it is used by the village public. It has not
No,
been
what
endowed.
does the ROR fix for?
Well,
What does the record of rights fix for?
record of right, it says, your lordship will look at the ROR.
Which Chandi Thakurani BJ.
Yes.
That
So
is,
it's a DT.
It's
a DT.
It's an endowment property. Hindu endowment property.
now the construction is being carried out within the premises of the Panchayat office, Gram Panchayat headquarter
No,
office.
so that's the
It's
question.
not on a DT's.
No, my lord,
land.
that is the instruction which I have received with the
No.
photographs.
Panchayat office might be constructing on the land, what he is alleging.
But the allegation is not with respect to the Panchayat office. It is the allegation, the construction of
Whatever may
the
be, Panchayat office.
facilitation center. The facility
Mr.
center.
Das, try to understand.
Well,
He has filed the ROR
yes,
specifying the khata and plot numbers.
yes.
So you give the reply whether you are constructing over said plot and khata number.
Exactly.
Whether it may be in Panchayat premises or in any other premises. That we are not concerned.
Specific
Is
plot.
there any construction over the said plot? That is so question.
My instruction.
You can't eat up anybody's property.
My instructions are,
That is not the proper instruction. Okay? Proper instruction. He has given the ROR.
And it is maintained by you, government. The government department maintains.
yes.
And if the record of rights shows that this land or a plot of land,
Then the entire
It's recorded in the
construction of
name
the
of a
Panchayat
DT,
office
that-
is also
so it has to
over
go.
that it is property. If it is
Any of the villagers, they are also there, they will go also, their construction will also go. Just identify, make a demarcation. If any of the villagers' house is also found, that has to go.
Yes, ma'am.
But in that event, the entire Gram Panchayat office has to
Let
go.
it
If
go.
it is-
How can, because you are the government and Gram Panchayat, therefore you can eat the endowment property and could make constructions over it.
No, my lord, here in this PIA, the only allegation is with respect to the felicitation center, the facility
Whatever, we are
center. I'm
not.
sorry,
You
the
tell
facility
us whether you are going to make any
Yes.
construction over the DT's land or not.
That I'll.
Mr. Das and
Specification.
LGA seeks time to get the specific instruction regarding any constructions made by the government officials over the deity's property as per the ROR produced under Annex 1. Without issue. List on 22nd April.
Item number 5.
Instruction is not received.
It's it. Item 5 will be on Monday.
22nd April as paid by Mr. Das and LGA.
Item number 6.
Sum of rupees 22 crores. Some odd person will see the demand notice was raised against the petitioner. That your lordship will see the demand notice. Annex 19. Page 19. Page 19.
Election.
Annex 1 and the proper page is 19. Then, my lords, I preferred an appeal. And because it is a high-pitched demand case, as per the CBDT circular and notification, this has to be disposed of. Now, I filed the appeal before the National Faceless Appeal Center, as your lordship knows, after 142021.
Is it not an appellable order?
No, I have filed appeal. Appeal is filed and the annexer 2.
So,
now, my predicament.
Appeal, you want an expeditious disposal.
Now, lordship
Say so, otherwise ready. Dispose it off within 3 months. I think there was a direction on the last occasion to ascertain what the appellate authority has said. CIT appeal.
Instead of disposing of the
CIT
appeal, they are now recovering. They are at the stage of recovery. That is what my information is.
Proceeding under 226.
Proceeding under garnishing. That is the whole problem.
Don't worry.
Your lordship, similar order has been passed by your lordship on 27/3/2025, directing to CIT appeal to dispose of the appeal expeditiously. And within 3 months, you give a direction, they will dispose of the appeal.
That will work.
And there's no recovery. If your lordship, I am not. That is up to your lordship. I am not.
You have come for expeditious disposal. You can't have it both.
That is
you can't have a cake and eat it too. Both.
No. Definitely
you have to choose one.
Yes.
Expeditious. If you want, you can pray for a stay before the appeal.
Yes. But let them dispose of the appeal within 2 months. Within 2 months.
Where is 3 months, your lordship?
Yes.
3 months, that was there when the order was passed on 15/1/81.
2 and 3 is hardly, there is any difference.
Okay.
The grievance raised in the instant writ petition pertains to delayed disposal of the statutory appeal filed before the Commissioner of Income Tax.
Faceless. Appellate authority faceless.
It was CIT appeal, National Faceless Appellate Center.
New Delhi.
CIT appeals, National Faceless
Appeal Center.
Appeal Center. The order of the assessing officer is assailed by the minister.
Page 30, your lordship will kindly say. I have,
but till date,
in spite
no
of
attempt is made on the part of the appellate authority.
Annex 4, page 30.
Dispose of the same. we are not unmindful of the fact that there has been a spate of litigations filed before the appellate authority. Yet we cannot overlook the fact that the litigant has a right to have adjudication on a speedy basis. Considering the plight of the petitioner and that the appeal is pending for a considerable period before the appellate authority, we therefore request the appellate authority to expedite the hearing of the said appeal, and efforts must be made to bring it to its logical end within 3 months from the date of the communication of the order.
OP number 1, Lordship, unless Lordship specifically say.
Yes, page OP number 1 on what?
National CIT Appeal, National Faceless Appeal Center,
Yes.
New Delhi.
Opposite party number 1, sir.
Yes.
No.
Matters, may I further pray one thing, Lordship will not take into, not mind. Any recovery made will be subjected to the outcome of the appeal.
That order you can get in the appeal.
I leave it to your Lordship.
Item number 9.
Audience admit.
Yes.
Item 9.
While the counter affidavit today itself, the Lordship has provided its physical copies of
Just
What do you want? And would you like to
respond to it next week.
You want to respond to it?
Counter affidavit has been filed by Ms. Patnaik and an AGA in court, and copies are to the
Speaker,
petition.
one paragraph, your Lordship, the senior can also hear your Lordship.
So he needs a time to respond to
It
it.
is for the,
I know, I have gone through. So let them respond. Mr. Rao and counsel and senior counsel for the petitioner, 6 time to respond. List on 6th May.
Item number 10.
In the meantime, the resender, if any, shall be filed.
Item number 10.
Please, Your Lordship. That was also directed to obtain instruction from the state government.
we have not received instructions in this matter.
The last order was 26th of March.
My department also for the detailed counter. That's the detailed counter in this matter. The department wants to put a detailed counter in this matter. That's
So
what.
these are all the detail of EIL. I do not appreciate that why the state would be treating this litigation as an adversarial litigation. The state should come up that what is his obligation under the constitution. Then he should file an affidavit showing that what steps he has already taken in this regard. Why come? Why for delaying it? This relates to, I think, some reservoir.
Yes, for Jonker.
Yes. And if you overload it, there is every possibility that there will be a casualty and the mass casualty may occur. That is what he has shown the concern that the level of the water should be at the optimum. So you should show some kind of a lucky in it.
That's last opportunity to be.
Come on the next on 15. Please, you'll have to take instruction.
Ms. Das and AC 6 last opportunity to take the instruction. Based on 15th.
I'm appealing for the Union of India opposite party number 1. My appearance may kindly be recorded.
Fine. File it in the box.
Office file. Item number 11.
When also last of the instruction. The allegations regarding cutting of trees from the school premises in Bangalore district.
What? Regarding, filling up the poles.
No, cutting of trees from the.
So cutting of trees, yes. Have you taken a permission from the forest
Minus.
department?
Yeah, we received instruction, but the name of the school is not matching, means I will not be able to.
Name of the?
Correct.
Only this spelling mistake is there.
Since I have to.
So name of the school is Srinath Chandra, no?
But the
Upper Primary School.
name is different in my instruction. My loss, I cannot place this.
So that school does not exist.
There's no instruction with respect to that school. There's some other school about.
So there was a mistake on your part.
That's the instructions which we have received, that is why I cannot place.
Your instruction, man.
That's next week, my lord. I've already spoken to him, my lord.
This class submits to get instructions as a last chance. List on 21st April.
Item number 12.
In this case, I have filed an application for intervention.
Who are you?
I am the license.
You are an existing license holder.
I have applied for shifting that has been challenged. The notice has been challenged by the present petitioner.
No, I am for the petitioner. I have challenged under Annexure 5. The public
No,
notice.
why he wanted a shifting.
He is coming to my area. Lord. By this notice,
If you raise
there is-
an objection, the authority will take into account. If you have any objection,
Lord, my ground is here. It is here that Rule 24 says before issue there is prior approval of the government is necessary. That is my stand, Lord. They have not taken any.
whatever.
That objection you can take because
You can raise this objection before the authority. Why you are coming?
Commissioner
petition here?
Lordship, direct commissioner, let me heard both parties and pass around.
Or they treat this as an objection and then take a decision.
No, I have filed objection. They have not considered. I have filed objection. Under Annexure 6, I have filed objection.
Madam, before you take a decision and permit the shifting, you are taking opinion of the public.
Yes,
So that objection, when it has come, take into account that objection.
yes, that is the.
Substantiated, unsubstantiated, you have to take.
While
the
taking the
petitioner
objection, I may be
has
allowed to
opposed.
participate, may be allowed to have.
All right,
You have applied for shifting,
Yes,
so you have to be heard.
yes, ma'am. That is that I have.
That's it. I also let both be
The
heard.
petitioner has come up in challenging the proposal of shifting of the IMFL officer, Bomikal IMFL officer, to from the existing site to a new site as per Annex 5. It is contended that
I am licensed. I am also licensed.
Oh, you are a license.
Yes. But
Of that area where
yes, where he is coming,
Okay.
the new site is I am affected.
I got it.
Because Lord,
Last villager.
last year I couldn't lift the MGQ blood. My quota has been I couldn't lift. There is no demand. How you can increase the subs?
it is contended
Better,
By
that
the-
should be a less demand.
Lordship,
For the sake of the public.
that is, I agree also.
It is contended on behalf of the petitioner that he being the licensee, having the area covered to in the proposed new site, has raised objections before the appropriate authority against shifting of the aforesaid shop. And his objections have not been considered. Accordingly, next one, considering such limited fair, before that, right? In the meantime, today,
refer
the
Rule 24.
Huh.
Because there is
Yes,
increase or decrease of subs.
Yes,
Proposed rule is 24.
Yes.
Rule 24.
Shifting is not.
in the meantime, today, the shop of the licensee of Bomikal IMFL officer has appeared and prayed for intervention in the writ petition. Next, however, considering the limited grievance of the petitioner, that he has objections with regard to shifting of said shop, we to the proposed new site, we feel it appropriate to dispose of the writ petition at this stage with a direction to OP number.
But OP number 2, Commissioner, Your Lordship, direct
OP number
because
2.
Rule 53(5) is the Commissioner is the authority.
OP number 2, to consider the objections rendered by the present petitioner in accordance with law, including the provisions contained in the Odisha Excise Act and rules. Stop. It is also directed that the OP number 2 shall consider the objections by granting an opportunity of hearing to the petitioner as well as the intervener who is the existing owner of Vomikal IMFL of shop and other concerns, if any, and dispose of by passing and pass a reasoned order within a period of 4 weeks from the date of receipt of certified copy of this order, along with a copy of this writ petition.
Item number 13.
Malad present writ application, the petitioner challenged the order of assessment passed under section 147 read with 144B of the Income Tax Act for the assessment year 2021 to be without jurisdiction, violating the mandates of the statute as well as the circulars issued by CBDT. Here is a case, Malad. The assessing jurisdictional assessing officer that the ITO ward deposited
such a huge amount of cash in the bank.
Malad, yes, I am going to that one. The very initiation of the reassessment proceeding is invalid in the eye of law because the jurisdictional ITO, that is the ITO ward Puri, has no jurisdiction, no authority to issue notice under section 148, and issuance of 148 is bad as because 151A says the assessment, reassessment, recomputation has to be made by faceless manner, and the faceless assessment unit has the power to assess and reassess me, not the ITO ward Puri. I have in my support, I have various judgments of various High Court.
Also there.
Your Lordship, assessment has been done by the faceless man. Assessment unit faceless.
It has been done by
Case number 37, lastly, it has been assessment unit, income tax department faceless.
Even if the
it is done faceless, then what?
I am giving this document where it says the initiation should not be made by the jurisdictional assessing officer. When the initiation is made by the jurisdictional assessor, the entire assessment subsequent action goes. It becomes invalid in the I block. I have given the various High Courts of, and also Punjab and Haryana have given. Then Guwahati, Bombay, similar view has taken my lord. Paragraph 15, my lord. From the perusal of section 151A, it is quite evident that scheme of faceless assessment is applicable from the stage of show cause notice under section 148 as well as under section 148A. Clause 3B, notification dated 29th March. Also, to that effect, the CBDT has also issued a notification that everything has to be done in faceless manner. Issued under section 151A. Clearly provide that schemes would be applicable to notice under section 148. Even from the very initiation of the one notice of one section under 148 has to be made in faceless manner. The object of the introduction of the faceless assessment would be defeated.
I understand that it says that so-cause notice has to be issued according to the provision of the Act.
Yes, ma'am.
In a faceless
manner.
Since it is done
by the
in a faceless manner, so even if the notifications or circulars are issued, those circulars which overrides the provision of the substantive act are not correct or is not legally binding on the court.
My lord, the circular, the circular that is internal circular to them. But here is a circular.
That is what I say. That is not binding on the court or the SSC.
But the Act says the assessment has to be made under section 151A in faceless manner. And 144B also says that should be made in a faceless manner. So the initiation has to be made in faceless manner, not in a, the jurisdictional ITO has no authority, no power, no competence to issue this notice.
Let us hear any other,
Yes, sir.
any other weapon in your armory?
Yes, madam.
Yes.
Well, Guwahati High Court, madam. Then Telangana High Court, madam.
This is a single bench matter.
Yes.
Does it bind the?
This is a past one is the division bench, madam.
That is there, but it has
And the
persuasive value.
that
Not binding.
Telangana is the division bench matter, madam.
Not binding on us.
The statute says it is against the statute, madam. In addition to that, also, my lord, there are several other issues which has been violated by the assessing officer. Legal issues are there. Because this goes to the root of the case, my lord. Unless this is decided, when the assessing officer has no power and jurisdiction to issue this notice, so the entire proceeding, subsequent proceeding goes, my lord.
Delhi High Court has gone against you.
Yes, Lord.
Delhi High Court has gone against you.
The case.
That is pending for the Supreme Court.
The case builder will not challenge.
Sanjay Gandhi promote your trust.
Also, lots of in a PKS builder also, recently in 2024, Delhi High Court has given that it can be done, judicial AO can issue the notice. And similar matters are there. Five matters. Calcutta High Court also.
Only thing is the adjudication in a faceless manner.
Yeah, Lord, the education has been done in the faceless manner. Page number 27.
But Punjab and Haryana says that the adjudication
It has been
is
done.
initiated or is started on the show cause notice. So it becomes a part of the entire process. So once it is set faceless, so the show cause should also be in an automatic or automation. It should be automation.
In this case, what happened, Your Lordship?
And
preliminary,
and he is relying on this judgment, which says that the government has also accepted it and framed a scheme.
That scheme itself also says that
2022 scheme.
judicial AO has the power. Page number 56, Your Lordship.
That has also been decided by this honorable court in the
Page number
case of
56.
Jatinder Singh. That has taken care of.
Page number 56, paragraph 12.
What?
Of the
56 of
scheme
what?
of our writ petition.
Yes.
It has been said if the information referred to subsection 11 pertain to the pending scrutiny assessment, it shall be available electronically to the faceless assessing officer or jurisdictional AO as the case may be.
What is this notification of 29th March 2022?
29th March, my lord, it is Annexure 8 at page 54, my lord.
Annexure?
Annexure 8 at page 54 of the jurisdiction. Scope of the scheme, my lord. Paragraph 3. Assessment, reassessment or recomputation under section 147 of the Act. A assessment, we issuance of notice under
It's an
section-
automated allocation in
Yes,
accordance
ma'am.
with the risk management strategy
Yes.
formulated by this.
Yes, ma'am.
So this is what your own.
Yes.
Your Lordship, if we go for an assessment order, what happened in this case?
No, there are two assessment, reassessment and recomputation.
Yes, ma'am.
Issuance of a notice under section 148.
Lordship, I'll let you. Lordship.
Both comes.
Yes, Lordship. Page number
And then says
61.
could be automated allocation.
automatic allocation has been done, but approval has been taken with the judicial commissioner. So 148 notice is being issued by the jurisdiction AO, which is allowable. Then after that, the assessment has been done by the faceless assessment unit, your lordship. And it's in an appealable order, your lordship. If you go for page number 61 also, 148A notice is also not required in this case, which is that we also challenge that. So 148 direct 148 notice is also required.
There is the plea of jurisdiction before the appellate authority.
The appellate authority will never decide the jurisdictional matter. And there are other issues also.
Law declared, that
When
the law is declared.
when the approving authority has also not acted in accordance with law, who has approved this for issuance of notice, the principal CIT, he has not also acted in accordance with law.
What is the date of the order?
Date of the order is your lordship 19/2/2025.
So it's the period of limitation is there.
Yes.
No, no before the.
But my lord, there are a lot of difficulties, my lord. This jurisdictional issues is never decided by the assessing of appellate authority. And when the
because of that, he cannot direct.
my lord, the commissioner of income tax has also committed error by approving this principal commissioner.
I understand. You raise this plea before the authority and let the authority come with a decision. I think the judgment of the courts are binding on them. If they do not, you have seen the earlier
circulars also
court has set aside that you can't avoid.
The circulars issued by civility also binding on them, my lord. They are not going by the circular.
This is what the 29th, the
29th March
2022 is in your favor.
Yes, my favor.
So how can they defy it? If you go and rely upon that, they can't defy the notification. So it's better to go under section
246.
246.
But the entire proceeding is bad in law, my lord, without jurisdiction. And then violating the mandates of the statute. Violating of the
appeal.
Take that. Is avoiding that statutory deposits.
In the meantime, there is no courtship action, my lord.
Is there any statutory deposit for maintenance of the case?
Yes.
Lordship, if you file an appeal, you'll have to move a stay petition before the assessing officer.
And then the 50% or 10% or
20%. If you pay 20% of the amount, automatically stay till the disposal of the first time.
And what is the total demand?
Total demand is 22 lakhs.
4 lakhs. 4 lakhs, 20%.
A poor man, my lord, he is an employee in the bank.
Who?
This petitioner.
No, he is not an employee.
Yes, madam. He was an employee of the bank, and he was working for the bank, and he was deciding the issues.
And you are dealing with the cash.
He was deciding.
No, you are dealing with cash.
Yes, madam. Deciding the issues
out of
to
that
settle the gold loans. And he was collecting the.
You are dealing with, sir, you are avoiding the answer.
No,
you are dealing with the cash, na?
I was collecting the cash on behalf of the bank and depositing in the bank.
So kept it deposited.
No, it was transferred.
Depositing in the bank account.
Initially,
this was
the amount was initially deposited in my
I can
account.
say anything. I have seen that. PINCOP.
Yes,
We have seen that.
I was
What
working.
you have done. Yes, come.
Some amount was transferred in time. Some was transferred in later on.
Why?
Because I have to work in the rural area and collect cash and deposit in the account. That's why there is some delay in depositing the amount.
We are not going more deep into the matter that where you hold the account and where is the account of the bank and where is the bank. We are not going into this.
My lord, I am called to raise all these issues with the appellate authority. We'll decide accordingly.
The order of the assessing officer passed in a faceless manner is received in the instant petition, flagging an issue that the jurisdictional assessing officer is incompetent to issue a notice under section 148 of the Income Tax Act. in view of the provisions contained under section 151 capital A of the said Act. And therefore, the entire proceeding initiated is liable to be paused and set aside. Several judgments of the different high courts are relied in support of the contention that once the proceeding is to be done in a faceless manner, the initiation being the show cause notice issued under section 148 is an integral part thereof. According to the department, the provision requires the adjudication in a faceless manner, which is admittedly done in the instant case. And therefore, it cannot be set, and therefore the contention of the petitioner does not appear to be correct. In course of the hearing, we found that there is an efficacious alternative remedy provided to the petitioner by way of an appeal under section 246 capital A of the Income Tax Act. Full stop. The points so raised in the instant writ petition can be raised before the appellate authority, and it is beyond capable of doubt that once such point is taken, it is an ardent duty of the authority to decide the same in accordance with law. It is inconceivable that the authority will shirk its responsibility in deciding the objections and the issues raised before it. And mere on an apprehension that the authority will not take into account such point does not appear to be apparent and evident. So, still the remedy of an appeal is the period for limitation to exhaust the remedy of an appeal has not expired as yet. Has not expired? Not 90 days. How much? 60 days. 30 days or 60 days?
30 days.
Now, past appeal is 30 days.
So what is the 30 days?
Then March. Then March.
But section 5 is applicable, no upper limit.
Though has not, though intervened, yet there is no pattern on the part of the authority in admitting the appeal in exercise of the powers conferred therein. Since this court refused to exercise the discretion and permit the petitioner to exhaust the remedy before the appellate authority, the appellate authority shall consider the case in the light of the same, in passing an appropriate order, and it is expected that the authority would decide the issue as at an earliest.
You get that no personal expense.
Deposit 50%.
Then I'll pay the extra for
Go there. Whereas High Court has a discretion, not bound by the.
Item number 14.
Lord, it's a directed instruction. Now, just now they have solved the counter. Approximately, and some time the file is under.
Lordship, his
Why
license.
you are not giving advance copy?
Lordship, today itself.
Lordship is short time with them. Lordship said,
Short.
because ordered on
Because there are
15th.
time.
So Ms. Patnaik files copy on behalf of the opposite parties. Files copy of the counter on behalf of the opposite parties. Files the counter on behalf of the opposite parties and subs copies on the petition. As prayed by Mr. Patra, who goes to the same and file his response. He needs 1 weekend. List on 22nd April.
At an hour 15.
Challenging the order dated at 13th February 2025 of the first tablet of the day on the ground of the lawsuits last opinions directed to the appeal memo. Therefore, I find the existing affidavit to be the lawsuits. Finally, in the page number 6 of the additional affidavit.
Your Lordship, the annexed form may be passed and remanded for hearing of merit. Now, because Your Lordship, after the adjudication, he has filed a rectification under section 160.
Okay, so the period of limitation would really.
On the date of rectification.
Absolutely. The rectification was allowed or rejected?
Rejected. So he has annexed the rectification order in the appeal. So he has filed the additional affidavit.
The rejection, can it extend the period of limitation or it is allowing will extend the period of limitation? Tell us. Which one is correct?
Your Lordship, as for me, it is to be merged with the rectification.
How can it be rectification of what? It's not a rehearing.
Your Lordship.
It's not extending the appellate jurisdiction. Simply, whether there is any error or a mistake which is there in the order, for that the rectification is done. Any ministerial error, arithmetical error, grammatical error, or whatever, is not a reopening of the entire adjudication.
I may rectify myself here. I'm sorry.
If it is rectified, definitely, because it will augment. But if it is rejected, then does it amount to merger?
Great plan.
And outer limit is there.
This can.
High Court is not powerless, I believe.
But since it is pending before the Supreme Court, Your Lordship, against the Calcutta High Court judgment. So, and many other judgments are there. So, Your Lordship may let him file appeal before tribunal.
More in that.
That's the problem.
Because I had also taken the same view that.
Your Lordship, only except Calcutta, all other high courts are different view. Patna High Court, different view.
Gujarat was with us. Gujarat was with us.
Patna High Court is against Your Lordship. Patna High Court, against that Patna High Court, on the Supreme Court on that day I have submitted. And so far as the HON'BLE India, Your Lordship, larger bench judgment, seeing enterprises, so far as the service tax, Your Lordship is concerned.
HON'BLE India has also gone to the Supreme Court.
Your Lordship, Supreme Court judgment, larger bench judgment.
Not a larger bench.
Your Lordship, that is in favor of the revenue. That is in favor of the revenue and identical parametric provision, Your Lordship. So far as the central excise is concerned. I'm seeing it by the
Absolutely, that is what is the problem, because there is a period of limitation, beyond that it cannot.
In identical cases, your lordship was.
No, I am very liberal in this regard, to be very frank, that you can go on. But once the Supreme Court has accepted and states the operation of the order, then it will not be advisable to pass an order that says that.
Your lordship, in identical matters, your lordship, since tribunal is not functioning, your lordship, the common order your lordship is passing, that you deposit 10%.
You deposit 10%,
Yes.
for a
The same order.
and then do whatever.
Yes, sir. Your lordship, the same order will be passed.
Yes. Perfect. Have you seen that?
Your lordship.
Check. Give a counter sign.
Your lordship, I'm sorry, I made a different myself, your lordship. I have confused.
Yes, call the next.
Item number 16.
This is regarding a construction of road, your lordship, in a TIL. Construction of a road for the villages.
Yes.
I was before your lordships earlier, my lords are directed for disposal of the representation, which was rejected with the collector, as against which I am once again before your lordship after serving.
What the collector says, that road cannot be made or road should be made.
Road cannot be made, though there is a, my lord, the assistant engineer and the RI, they say.
There is a pressing need of the inhabitants, according to you.
According to me, and I could not file this along with the application because there are restrictions regarding your lordship registry, unless the documents are clear.
For legible copy.
Not legible, this photograph, that your lordship may kindly look at, this is the location of the road. Already is being used by the villagers and they are working through it.
There is no other way except that.
No. Whatever roads are, it's a question of road.
See, it is passing through a Chota Jungle.
Chota Jungle.
So Chota Jungle, that road, there is no other way getting out of the village.
In fact, your lordship, road is a road, your lordship, I understand. What? There is no road. No road.
Except that there is no other.
No road. No road. It is being used, your lordship, to see the photograph.
You have rejected it.
That's at page number 17 is the order of the collector. I'll just read my notes, the concluding paragraph at page number 17. Let's read. And whereas an examination of above records and sketchwork submitted by the tehsil that it is ascertained that the land bearing so and so, a moja so and so is recorded at page 17, my lords.
Yes.
Annexure 2.
Yes.
Third last paragraph.
Yes.
And whereas on examination of above records and the sketch map, that paragraph.
Abada Joggo.
Abada Joggo Anabadi.
Having Chota Jungle, having Kisam Chota Jungle alleged and claimed to be used as road by villagers of the so and so village at large is not based on fact. As the earthen road is not being used by the villagers for the time being, there is no need for construction development of the road over plot number 125. What's the reason for rejection of?
Fact finding reports are.
Page 20.
This plot number 125 is recorded as what? This is the Chota Jungle?
Chota jungle.
Chota jungle.
Chota jungle.
Page 20, your lordship.
Really a forest.
Village. Sure.
And once it is a forest, then
Clearance has to be.
removal of the trees.
There is no tree, there is a road, your lordship.
Somebody has removed,
That is being used as a road, walking road, Pagdandi, my lord.
the entry in the record of right.
That I am conscious of. Now, your lordship, may kindly turn to page 20.
Sacrosanct to some extent unless you show something.
Page 20, your lordship, may look at it. Page 20. There is the assistant engineer's report.
Maybe.
He was called for a report, my lord. I visited the block. Block.
But authority has to give.
Collector had inquired. Collector asked all them to give reports. Inquiry report such and such. With due respect, I visited the site along with assistant engineer on date. Your lordship finds that page 20. On 24/4/2024.
This simply says that this can be utilized for the purpose of the construction of the road and it will facilitate the interest and interest of the local villagers.
No, there is another aspect to it.
That's the only thing.
People of the locality are using the road pathway on earthen portion. This earthen portion already being used.
Even a forest can be used by walking over its. There is no difficulty. The moment you wanted to make a metallic road, you wanted that.
Yes, your lord.
That it should be a metallic road.
Because during
then the question of removing the forest, the trees, the removal of many things, and really the conversion in relation to the user of a particular plot of land, if they say being a forest, you can't touch it.
There is no removal of trees, my lord.
Who has done, they do not know.
But the construction of road over a Chota jungle is prohibited unless it is notified.
Lord, what I am submitting is it is already being partly used during winter, during rain. Our problems is really that multiplies.
That fact is denied by the collector.
You not see
The inquiry report of the collector has said, as read by Madam Das. But it is not a fact.
It is about 200 meters away from the existing road from Blind Hostel to Gothapatna plot section is near about 200 meters. The only road is, my lord, 200 meters away. So the question of construction of a 200 meters plot.
And this Chota jungle alleged and claimed to being used by as a road.
Road.
By the villagers of such and such village at large is not based on fact. The fact is different.
Achha. But in the second paragraph, page 17, my lord, video Bhubanesh. Hello? I am a villager, my lord. No, not somebody. Not a busybody, my lord. I am a villager. Whereas the video of Bhubaneswar has also submitted his report by letter dated such and such, wherein it is reported that the position of
this letter which we are referring at page 21, which is the name.
21.
Yeah, whatever. It ends at 22.
22, that is my representation, your lordship.
Yeah, this is what is your, no, this is your representation.
My lord.
And where is the report of the assistant engineer?
That I was showing your lordship, page 20.
Page 20.
20.
Yes.
With due respect, I visited the site along with the assistant executive engineer on 24/4/2024. We found that now the position of the existing road from Blind School to Gothapatna Road to number 125 is near about 200 meters. There is an existing road from that is 200 meters away. People of the locality are using the road pathway on the earthen portion. Position they have written is possibly portion. There is no building construction to connect this road. They have demanded for construction of Pakka road over the earthen pathway surface for future construction of building. So whatever earthen surface is there, on that only we are asked. We are not seeking for any removal of trees. Now your lordship say Chota jungle and all that. I have shown you the lordship photograph. This is the jungle position. Let her take instruction whether there is anything bigger than this. It is a Chota jungle, time immemorial. This is recorded as such. Nature has changed.
So they have.
I have given her a photograph.
They have to take a decision, and they have taken a decision.
I have given her a photograph.
And they have decided not to convert it.
The conversion part they are not saying.
No, they have said.
They are saying the
that it
collector is
remains
saying.
the Chota Jungle and therefore cannot be used.
My lord, it is
This is at page 17, the order.
Yes, as the
Hence rejected.
as the earthen road is not being used by the villagers for the time being,
Nothing.
there is no need for construction development of road number 125. At this, I don't know where from the learned collector got this, because it is clearly written in the report, inquiry report, spot inquiry report, this is pathway is being used.
Whatever. Yes.
Should I go back to the collector again? I've given a photograph now, Your Lordship.
That was there in your representation.
I think Your Lordship opined that there could be removal of trees involvement, but it is already flattened.
What is the interaction? That may not be reflected in the order, sir.
My lord, the collector is saying it cannot be. If Your Lordship says that the collector is right,
you know the view of the Supreme Court in this regard. But the forest land is there.
But let them.
How it is to be preserved.
So let them give us an alternative land, alternative road.
Why? There are many in the hills where the villages are at the remote place. There is no metallic road. They have to walk at least 2-3.
My lord, days in and days out.
Those are the hard realities. One has to embrace it.
But then days in and days out.
Remove the forest. This is what is.
I am not seeking for a removal, my lord. But days in and days out, Your Lordship is saying no negative equality. Sir, somewhere it is not there. So should I not have it? Your Lordship is saying no negative equality. That is, I quite agree with that also. Your Lordship may consider the villagers' case. It's not a question of.
It is really a sorted state of affair that the area which is included in the reserve forest in the record of right maintained by the authorities.
Reserve forest?
Village reserve? No, they say reserve.
Village forest. No.
Village.
Chota Jungle, village forest.
Is a village forest. Is being gradually eroded. And are diminishing because of the rapid urbanization. The record of right has not been corrected, nor the conversion has been permitted by a competent authority as of now. The villagers who have approached this court approached the authority for construction of a metallic rod passing over the plot recorded as a village forest in order to ensure seamless connectivity and or communication to the main road. The conservation of the forest and its gradual corrosion is a matter of serious discourse globally. And all the educators, researchers, and the judiciary has echoed in one voice that some checks and some restrictions must be imposed as imbalance in ecological system augments the global warming. The forest lands and its conservation within the village is to ensure the equality and the balance in the ecosystem. And therefore, deforestation by uprooting the trees, shrubs, herbs, and any vegetation which grows naturally shall have a cascading effect in the climate, which the entire globe is facing. The plea is sought to be raised that the mud pathway is used by the villagers, being the means of their communication, being the means of their commutation, would not, in effect, bring any radical changes, nor will impact any impact the ecosystem. And therefore, the authorities should not have taken a conservative view in this regard. In rejecting the representation solely on the ground that the plot of land is recorded as the Isam, what is this?
Chota Jungle.
Isam Chota Jungle. The photographs are relied upon and placed before us in order to corroborate that there is no trees to be uprooted for construction of a metallic rod. But the pith and substance of the entire state of affair leads to an inescapable conclusion that so long the said plot of land is recorded as a jungle, the Kisam Chota Jungle, there should not be any construction activities. More particularly, the use of the construction material which would impede the vegetation and the natural growth of the soil. Stop. we would not be incorrect in perceiving the gradual conversion of the forest evident from the photographs produced before us. So that at one point of time, there would be a complete elimination of the trees, shrubs, and the vegetation. For which the state and its instrumentality must take a stern decision in this regard. We thus do not, though we do not find any infirmity and or illegality in rejecting the representation filed by the petitioner, but equally we cannot absorb our responsibilities in reminding the state or its instrumentality to preserve the said the forests. And curb any encroachment from any corner which had corner having an intention to utilize the state land for any sinister purposes. The writ petition is dismissed.
Some alternative somewhere.
Sir, recently in an Antwerp, because we used to hold a circuit bench at
Yes,
Antwerp also. So there are a lot of forests, and because of this urbanization, the forest lands are being used for this purpose. The Supreme Court, there is one special writ petition, not special, it's a Article 32 writ petition which is pending with the Supreme Court, and the orders are passed to restore back those forests. Even a court premises which is situated in one of the districts is to be removed just to restore the forest.
Now that your lordship matter is over, did your lordship think that it is for the transportation of construction material? No, my lord, that is not the purpose.
It's not a construction material. Sir, now it's over. The real, what is latent has not been projected as a latent. Latent intention is something else. We are very conscious about it.
Why can't we see the truth, your lordship, instead of looking for the truth? Never mind.
Item number 17.
This is the matter day before yesterday. The hearing has been completed, your lordship. Judgment has been reserved.
You wanted to file a note.
Your lordship. I filed and I have also
Also, we have filed, my lord. Also, we have filed at copy given to the site.
And this is by,
Your Lordship, my appearance
oh,
was
this is
posted
the
along,
starting.
Your Lordship, along with
You.
my additional standing.
And this is there. You will take care of no digital. Record the written notes of argument as directed above. By today, we taken on record. Hearing concluded. Judgment reserved.
My lord, petitioner is also filed.
Yes, sir. Confiscation, we will decide it, don't worry.
My appearance may be recorded along with additional standing.
That's, yes, that's.
Additional standing.
Yes. We will ensure for some good reason.
Your Lordship, Your Lordship.
Ensure you record your presence for some good reason.
Yes, clear.
Obliged, my lord. Deeply obliged.
For orders item number 18.
But there is a delay of 39 days and the copy of a limitation petition I saw from the attached.
Item 19.
A copy of the redoubling of farm.
At 19 March, allotted to Mr. Bimbisar that the government person medical emergency has left. He requested me to alternate.
It's a matter of 2002.
Yes, madam.
So I will ready for.
I will arrange him day, tomorrow or day after.
Item number 20.
But in this case, your lordship last time observed that the work would be executed by superintending engineer. But actually that needs correction because superintending engineer has been entrusted the fund by the government and CMC has to do the work. Today I have called the superintending engineer here. And he is saying that he talked to the CMC and they have assured that within 15 days they will start the work. Drawing and everything is approved, that is with the CMC.
No, lordship, can't attention one point. In 2021, December 2021, and lordship constituted a committee to inspect the Sisu one. On that inspection report, we have submitted, the engineer submitted report that it will be operated by March 2022. And also inform the committee that there is no shortage of fund. In spite of that, now 3.5 years has been passed in the meantime. One thing I have drawn lordship kind attention. It's a Sisu one. It's a children are treated there. The only largest hospital facility available in the Odisha. That apart, a drainage fund they have praying after completion of the building. That creates another problem. And another thing, the ISM is not converted. The building is constructed. Fire safety not given due to ISM of the plot. The plot is not belongs to Health and Family Welfare. Plot belongs to Revenue Department.
What is it, sir?
ISM plot, Jagada of the plot where the building is constructed.
जो आकाश जो क्यों अनावधि और
ना नहीं से जो से थिला जो रेवेन्यू डिपार्टमेंट को तार ऊपर नहीं
That process is over, that is transferred in favor of the superintendent. My lord, here the only question is, this drawing that was submitted on inspection to find there are certain low lying lands there that is needed some recasting. And the recasting is done, then administrator approval, everything is over. Now it is with the CMC, she has to execute it. CMC commissioner is because they are in BC my lord to reply to your lordship's query.
And superintendent engineer saying that he talked to CMC engineer, they said that in 15 days, they will do the tender and do the work.
But the difficulty is now, when you take such a long time to float a tender, then there will be a finalization of a tender, then the work order is to be issued, and thereafter you have to give a considerable or reasonable period of time to commence the construction work. When it will end, can the child wait? I'm just asking, if any emergent situation arise, if there is dearth of facilities, the dearth of the amenities, then what will happen? Who is responsible? Each and every, I would say, major citizen of the country or the state or the locality is answerable for their children.
Yes, madam.
Why?
Madam, Commissioner of CMC is available, you lordship, and ask him. They are saying that within 15 days they will start the process.
This matter is pending for a pretty long time. Several orders have been passed, and the serious concern is shown with regard to these facilities, amenities, and infrastructure to be provided for running this particular Shishu hospital.
Only the drainage part remains, and every other aspect, those are.
Why is a CMC have to? There must be an underground drainage system. Drainage system here.
Namaskar, sir. Additional Commissioner here, sir. Only, sir, day before yesterday, we have received a request from Superintendent Engineer Kota Karan Division 1. CMC will take up the drainage maintenance works. Within a week, we'll float the tender, sir, and execute the work.
There is last time, if I remember, that yes, last time when I still remember that it was shown that their building has really come up. The ground floor is used for some limited purposes. The other floors cannot be used because the drainage, the sewerage system or the connection was not established. Why? If you have seen that the construction is complete, you'll have to issue a CC certificate. I think the completion certificate has to be issued. After making a verification, is the municipality who can do or a corporation can do.
My lord, till now the building has not been handed over to the health department. That is handed over.
No, last time they say that one ground floor or a portion is being used for some. But the remaining cannot be because of the sewerage system not connected. So take a decision immediately.
May I place the relevant paragraph of the last order, madam? That will be relevant to decide the issue. Last occasion, that is the order dated 2nd April 2025.
Yes.
Relevant paragraph is para 2, madam.
Correct.
May I place, madam?
No, we remember because we were there and passed the order.
Yes. Last occasion they said that superintendent. No, my lord. Superintendent. In this case, what happened? Government money comes to the superintendent engineer. And superintendent engineer, as per the requirement, CMC will release fund. They will do the progression work from the time to time. They will send requisition to superintendent engineer. He will release the fund. Because CMC for this work, government cannot directly transfer fund to the CMC. Through superintendent.
Sir, the difficulty is either you create some kind of a synergy amongst the different organs of the state. I think that is what is most needed in, I would say, the good administration to be ensured. Problem is the one department says not my job, another department says not within my department. I am not there to see it. Things gets jumbled up when it has to be routed or when there should be a different departments who should work together.
Since 1994, there was a joint meeting. It was joint resolution as passed that CMC has to do it.
So why the CMC is not doing it? That's the whole thing. Do you not provide a fund? Do you not nominate your officer to be a part of the committee of the CMC?
Present here,
but Mr. Court, on the last occasion, you have said, as recorded in the order, that the work has been entrusted to superintending engineer, R&B.
That I did not say.
That you have said.
Because the environmental, I pointed out to the letter that was addressed by government giving fund to superintendent engineer. On basis of that letter, my lord, there has been observation. That's why
That is what I'm saying. That is what is there. I see. Proposal of 8.09 crores
I didn't say so.
for drainage network. You have said that in this respect, the execution of work has been entrusted to the superintendent engineer, RNB.
RNB was
Division 1, Qatar.
Yes, that is the environment that has come up.
No, not inward. Sir,
I showed you.
I tell you very frankly, when I record an order, I ensure that what is told to me is reflected in the order.
My lord.
I never record anything out of it.
Sorry, my lord. That may be corrected. No, CMC, your lordship, my observe. CMC, you have to do it within town. You can ask the additional commissioner by what date they have to complete it.
So your
They have to file an affidavit.
according to you, what is your statement made on the last day
That
is not correct.
Correct, man. Sorry, man.
On your part.
I referring to a particular document. I
No,
didn't know.
there are two
correct on
things,
your part.
Mr. Counsel. The statement made by you was not correct, or the order recording your statement is not correct. Tell me.
Sorry, my lord, what has happened, but actually CMC has to do it. If any wrong submission, my lord, did
So it is not correct on your
I
part.
mean,
I mean, that, Mr. Kaur.
I am pardoned, my lord, for that mistake. And this is the letter what
Whether you admit that, we are not going to admit that we
I
have recorded.
submitted, so I admit it, that is a mistake, I pay apology.
Now, how soon this can be done, Mr.
Commissioner.
Commissioner?
Assistant Commissioner. No, or assistant.
Sir, we'll float the tender within a week, sir.
Yes?
We'll float the tender within a week, sir.
Within what time you will ensure that the entire work is completed? We do not want what you will do. We want how the work is to be completed. And within what time?
When and how?
We are not concerned with how. We are concerned with when. Within what time? When it will be completed. Yes?
Sir, I will consult with city engineer and approach the honorable court, sir.
We are keeping this matter on 15th. You consult it and give us a tentative time within which you have to complete it.
Miller, sir.
Let him come. Say that within what time they will do. Yes. The learned government advocate appearing for the state submits that though on the last occasion, that is 2/4/2025, it was submitted before the court that the execution of the work has been entrusted to the superintending engineer within bracket RNB Division 1, Cuttack. And the drainage work is likely to be completed at an earliest, but it was subsequently detected that the entire the entire exercise is to be done by the Cuttack Municipal Corporation. The assistant commissioner or additional commissioner?
Additional commissioner.
The additional commissioner. CMC is virtually present and informs the court that the process of tender has already been initiated and likely to be published within a short interval. Stop. The submission leads to a presupposition that the CMC have taken a burden of execution of the work, including the drainage system, so that the building already constructed can be made functional. we inquired from the additional Commissioner CMC about the timeline within which the entire work would be executed, for which he prayed for an accommodation to consult the relevant engineers, or concerned engineer, not relevant, concerned engineers. Full stop. In such view of the matter, let this matter be listed on 15th. So we have recorded no difficulty for future.
Madam, on 15th, you have to file a affidavit to the work will be.
Let them intimate why are you in a hurry? Let them intimate.
Sir, we are also very sensitive as you are. Both. Don't worry. For children, definitely.
Present, you will should know.
No, why? We have not directed his presence.
Not directed, I said that what the profile.
No difficulty. No difficulty.
Item number 21.
Take certificate and immediately aspect for being looked into by the Honorable Court. Letter of PI.
Last day I submitted to your office that affidavit dated 6 March. I mean, filed that was not on board. It has come, my lord. I have filed that midday meal and take certificate. This think they have been got appointment.
Yes.
Earlier we have stated that from out of 105 teachers, health teachers, we have.
Sir, you are appearing as the amicus curiae. You are, sorry. I stand. Yes.
Your Lordship, kindly see affidavit dated 6 March 2025. I have enclosed all the documents. Regarding midday meal, there is no discrepancy.
Is very satisfied.
Allegation was
that part of the concern of this Honorable Court in the PI, as per the PI, it has been addressed in this affidavit. They have stated midday meal, there is no siphoning of funds.
Okay.
The balance part which remains is now has to be looked into is that with regard to the fake certificates and fake
Yes.
teachers.
Yes. Correct.
As per the letter of PI.
Recently, you have seen the Supreme Court 3 days before have scrapped the entire appointment of the teachers.
Yes. Here, my lord.
Fake certificate.
They have been thrown out of job. Criminal
be.
prosecution has been initiated. And some people, after having been thrown out, they approach this honorable court. Such few number of cases are pending.
Assist your lordships.
Is there any interim order or status quo to be maintained or something? So they are out of job.
Out of job.
No difficulty. So matter may be pending, but so far as the rest, others, there may be more.
They have been thrown out.
In fact, if the lordship has look at my synopsis, which is at the top. Synopsis number 2.
Synopsis, where do I get it?
It's at the top, I think.
You do it,
Yes,
find
sir.
out.
Sorry. At the top.
Oh, at the top. Yes.
The lordship sees the first 2 pages. I have in fact brought down the entire affidavit details in this synopsis. If the lordship sees this.
You have seen the first table is a table of teachers with a fake certificate dismissed, already dismissed.
Yes.
So no difficulty. And then
89 teachers. Then the second table which shows that subsequent affidavit.
this is also dismissed.
Yes.
No difficulty.
230 teachers.
Yes,
Now,
then-
out of the my summation is out of the 30 districts, 27 districts combining both first and second table have provided their respective data in pursuant, and 319 teachers with faith today have been dismissed.
Yes.
And if your lordship comes to page number 4,
Yes.
above is 319 teachers with fake certificates in addition to the previous status report which was there was 105 teachers. So I have come down, if your lordship comes to small Roman 4, I have stated that there's in total
424 fake certificates cases have been taken up for culmination, and all of them is gone.
As per the affidavits filed there.
Yes.
And if your lordship comes to the 3, serial number 3, in fact, small 5 shows the status report from 3 districts, that is Bargarh, Kendra and Kendrapara have not
Awaited.
awaited.
Correct.
And serial number 3, if your lordship comes,
cases which are in which investigation is under process.
Yes, as per their affidavit. Counter affidavit dated 21/7/2020. They have stated that.
What has happened to this Borga and Yonjar and Kendropara?
We have not received those reports.
Why?
Awaiting.
Why?
Have they not?
No, as per the affidavits. As per the affidavit, those three districts, I think they'll.
Why the status reports have not
We
been?
have not received. We have sent them a reminder. I'm expecting.
And when this was filed?
Sorry, no.
When this was filed? This second synopsis?
You have that is not going to be that is the.
No, this is already there.
It's 24th December.
24th December it has been filed. So
My friend is referring to the synopsis, a copy of which is not going to be that is the.
Service has been done, but I think he doesn't have it in person. I'll give it.
I don't have that copy.
There's nothing administrative about it. I'm just assisting them.
B Tech CV, it is all there on the.
You give a e-copy.
No, e-copy is available.
Yes, that is my point. Actually, I was not here. I was in the hospital. But that is why I can go to now. Otherwise, in that I could.
So please ensure that's why the status report of these three districts are not there.
Yes.
And then you have said that so far as these Angul, Kotak, Ganjam, and then Jharsuguda, Sugar, and then Mayurbhanj and the Sundargarh. These are the districts where there are still certain numbers which are under process. So disclose that what steps have been taken with that.
Entire everything I'll disclose.
Because this is their synopsis. You have culminated it.
Yes.
You have culled out. So this is what you have to do.
Yes.
Assist your lordship, I just.
Yes. No. Thank you. That you have really the crux thereof has been. The affidavits of the state reveals the strict utilization of the midday meals fund. And till date, there is no report or the complaint received over its misutilization. However, the other issue, which in our opinion is serious in nature, pertains to securing the job of a teacher on the basis of a fake certificates. The affidavits filed by the state revealed that 424 teachers have been identified having a fake certificates to secure the appointment, and an appropriate action has already been taken against them for their removal from service. It further appears that investigation in respect of 6 districts, as mentioned in a counter affidavit dated 21/7/2023, are under process. But no information is diverged by the state on the fate thereof. It further appears that the status report from these 3 districts, that Borgor, Kyonjar, and Kendropara, has not been furnished, and therefore the state is directed to ensure that such report is made available to the court as well as the amicus curiae on the next date. The state is further directed to disclose the status of the investigation disclosed in the counter affidavit dated 21/7/2023 on the next date. When we get
The additional affidavit dated, additional counter affidavit dated 2/7/2024, both.
additional affidavit, counter affidavit dated 2/7/2024. When? First week of May? First week of May. 6th May. Yes, give it on 6th. 6th. Four?
40 and 41.
Yes.
Identical matters posted to 5/5/2025.
5/5. Bring the other side. Who is the other side?
Excise matter.
41.
40 and 41. Excise matter, counter not filed.
180 ml. Posted to 5th of May.
5th of May. So it will appear 40 and 41. See.
40 and 41.
Okay.
Item number 23. 23.
We passed.
23.
In 23, I have been engaged today because the previous council passed away.
Mr. and senior counsel submit that he has been engaged for OP number
1.
1.
Yes.
And he seeks time based on 24th April or May.
First week of May, if you're African.
First May. First.
Little man.
Item 24.
Challenging the next of HARISH.
Not happy with this annexure?
Hello?
You are not happy with this annexure? Annexure 5.
Challenge on only one ground, subject to a lordship's acceptance.
What?
For Anganwadi worker, an advertisement was issued.
When?
My lord, that is
2021. So we are in 2025. What has happened?
look, we are in 2025. I am having a case, so for which I am before you.
Yes.
My lord, as per the advertisement, apart from other qualification, one of the
Did you participate?
Yes, I have participated.
You participate.
Yes.
And can you go and challenge the process?
My lord, I have participated since an illegal order was passed.
What
I
illegal
challenged
order?
it by filing an appeal.
What is, no, that's true. I'm asking, so far as the rate is concerned, you participated in the process. Now, can you turn around and say that this eligibility criteria is wrong, this should not have been done?
No.
Can
I am not challenging the eligibility.
Recruitment process.
I am challenging that the advertisement which was issued has not been
Issued in proper manner.
No, not proper manner, has not been carried out by the authority.
Carried out means?
Carried out means, my lord, one of the conditions was the candidate must know how to read and write ODI.
How to?
Read and write ODI.
Okay.
Yes, that has the candidate who was selected, who has been selected, she doesn't know how to write and read ODI in view of
How do you know that she doesn't know how to write?
She has passed CBSE from Delhi.
So what?
My lord, that is the crux of the matter because she is having no qualification so far as.
So what is the, I have passed from the ICSE board, but I know the local language.
Local language.
You see, but he might have been passed that Odia examination.
No, that is she filed a my lord certificate which is found to be fake.
The authority has not found. The authority has not found.
Authority, my lord, your lordship may kindly turn to that annex of 4. Annex of 4 is the appellate order passed by the appellate authority. Your lordship may kindly turn to page 23.
The opposite party put appointment for challenge.
Yes, no, I am the, yes, I have challenged. I have challenged the selection of OP number 6.
Because it was based on only the headmaster has enclosed that she does not have that.
My lord, your lordship may kindly turn to page 23. If your lordship allow me, I'll read it out.
Oh, the selection committee, it is only the requirement was the ability to read and speak Odia. That's all. No qualification is required that you have to pass the examination with the Odia subject.
Yes.
Only thing is to speak and read. So the selection committee must have examined, and she must have read it. No difficulty.
No, my lord, no interview was conducted. Nothing was conducted. Only
Selection committee must have.
Selection committee only, my lord, consider the certificates.
Sir, the CDPO, this in her written submissions before the appellate authority clearly stated that the Sunita Malik can speak, write, and read in Odia. So what more is required? No certificate is required.
Kindly don't to
the definition of speak, to write, and read Odia. How can you define it?
My lord, she must, because elementary education must be there.
How do you say? Is there any criteria prescribed?
Only read and speak. That's all.
Read and speak also right. Because she has to give the elementary education to the.
True, that is what has been held by the selection committee. Yes, she can read, write, and speak.
My lord, your lordship may kindly.
So then it's a evidence which is there. No. No.
Your lordship may kindly bear with me.
Proficiency in the language is important. If she can read, write, and speak, that's all. So she has to go and read class 2.
Madam, there are judgments of these courts in different aspects, in other different laws, to define how to speak, what is mean by speaking, reading, and writing Odia, as in the Panchayat Act.
Panchayat Samiti Act, yes, Panchayat Samiti Act, but my submission before your lordship is that if your lordship, let me go through it, otherwise, let me go through.
Justice M.M. Das.
Let me go through it and I.
Go through it.
Yes.
But there are 2 Supreme Court judgment is also against you.
If it is there, my lord, I don't have a case, your lordship may dismiss it.
Yeah.
I don't have anything to say.
It is only the proficiency in a particular language does not mean that he must have the elementary subject or a subject to pass in any competitive exam.
It may not be.
No,
She
it's
must
not that.
able to write Odia.
Well, how do you know
If he
if the authority
write
says?
Odia or, then he is also able to be
My
considered.
lord, my lord, that will not do. That will not do because preschool education she has to give.
Absolutely.
He is able to write.
My lord, she has to give the preschool education to the.
No, that is not a condition. You say the condition is only read and write Odia. That means only the proficiency, the knowledge of a particular language Odia. That's all.
Your lordship,
It does not require that in a class 10 examination, the Odia will be one of the subjects
that is true.
where one should pass the examination. No, that is not. Anyhow, come with that. I think something is against you.
If it is against me, I'm not pursuing it.
Mrs. Zena, take some time to satisfy this code regarding the criteria for reading, writing, and speaking Odia.
Yes.
As for the advertisement.
That's good.
List on 38.
Oblates.
Item 25.
Done. What remains? That's your grievance.
No, this level, so far as our knowledge is concerned, we have.
But now they have come that they have done it, all the notifications and everything. And if somebody who is not doing it, they will definitely take an action against the violation of the rules.
I may read a second and third paragraph.
What do you say on this?
We have not received any.
They have not given any.
Mother, this is in the form of an instruction, mother.
So the notification is dated. You have said that in compliance with such rules, a list of districts such and such have been displayed in official website.
But it has to be displayed in every fair price shop.
Yes, subsequently, my lords.
Where is the portion?
PRTA district grievance redressal and all collectors were requested to furnish the present status on the above to this department complaint of the orders of this honorable court. All districts have reported that display boards containing name, addresses, telephones, email addresses, and other means of contacting the district grievance
Oh,
redressal.
it has been installed in all fair. So it has been installed. So we'll take it, taking this on record that all the districts they have given, and there is nothing. Your grievance, your purpose is served.
It's a PIL, na? Okay. Then we are disposing of recording this. Give him a copy. Miss Das, Lenin, AC, submits upon instruction that in compliance to the National Food Security Act and rules, the government of Odisha now has published the list of district grievance redressal officers of all 30 districts and 30 districts in the official website of Odisha State Food Commission. Stop. Further, all the PD, DRDA district grievance redressal officers and collectors have been requested to furnish the present status regarding the compliance to the direction of this court. And accordingly, it is reported that all the district grievance redressal officers in bracket DGRO have been installed in all fair price shops, key public places in terms of rule 8 bracket 4 bracket small b of the Odisha State Food Security in bracket targeted public distribution system bracket end rules 2020.
The written instruction given to Ms. Das from the department, as a copy of the same is served to us supplied to us in court, is kept on record, including enclosures. In view of such statement made on behalf of the department, made by Ms. Das on behalf of the state opposite parties, the purpose of the petitioner is found to have been served, and as such, the writ petition is disposed of.
Item number 27.
And for the here, Lordship has directed copy to file the objection for condemnation of delay. The last occasion.
What is the delay day? Delay
31.
31 days. So IA number 7045.
Service affected?
Miller?
Service affected?
Well, I am appealing for the opposite.
Okay.
Respondents. Today.
What is the IA? Yes, IA number 7045. Are Mr. Vehrana, Mr. A.K. Jena for the appellant and Mr. Tripathi, who appears for opposite part of the respondent. For the respondent. Upon hearing for both parties and considering the grounds, blah blah, delay condoned and IA disposed of. Then read LWA list on 5th May.
Today, I have appeared.
No, we have recorded you.
Item number 30.
Then what happens? So counter is to will file result. Counters will file by OP 6 and 7.
You are for the petition.
I am for the petition.
Results you want to file.
We will file the result.
To the counter of OP 8. OP 8. Mr. Mahapatra and senior counsel for the petitioner 6 time to file rejoinder to the counter filed by OP number 8.
Well, that is one little modification because amendment a petition was filed and the amendment was allowed in the last order dated 5th of February.
But the amended copy has not been.
No, amended copy has also been
Consolidated
filed.
copy, consolidated petition has not been filed.
Yes, filed.
Then
and file accepted. But the note sheet in the positive showing that the amendment not allowed, list consolidated
List on 1st May. The office is to verify earlier order passed regarding amendment.
I am appealing for the opposite part 14.
Your name is there.
My name.
That will be.
Item number 31.
For the petition. First May. 31. Who is for the petition?
31 minutes. But on transfer, I have received to be filed also. I have filed my Vasanat number on 11/2/2025. But
So you are Mr.
I am B.S. Paningri.
So P.S. Panigrahi admits that he has entered appearance for the petitioner upon consent of the earlier lawyer. And filed his Vidama on
11/2/2020.
11 February 2025. His name may be indicated in the list, and the name of earlier lawyer may be deleted. I can ask for the other side list on 7th May.
I am appearing for opposite bed number 5.
Escort for okay.
Well, I am appearing for opposite bed number 6 to 10.
You are Mr.
Rajkumar Jintu, sir.
Aapke Jena for 6 to 10. Next.
Item 32.
I speak through my voice. I have a petitioner in person. This is a public interest litigation for access of wheelchairs into Jagannath Temple.
Access of
Wheelchairs.
wheelchairs.
In this context, my lords, I have filed a case, a public interest litigation in the Honorable Supreme Court in 2018. Pursuant to that, certain directions were given. And part of that directions, an affidavit was filed by the Chief Administrator of Jagannath Temple that they will ensure access of benches into the Jagannath Temple. Pursuant to that, the matter was disposed of later on, saying that any grievance that I have, we may move the High Court for the same. And in this context, my lords, after filing this case, the petitioner, the opposite party had appeared and had filed an affidavit on the last occasion, after which the Honorable Court had ordered to file
Number
further
two, to
affidavit.
file a detailed affidavit in this regard. Are you who is OP two? Chief Administrator.
And for the temple, we have instructions.
You are for Chief Administrator.
Yes, sir.
So you have not filed your affidavit today?
My lords, we have just received the instructions to appear. Requesting for a short adjournment. They are yet to receive the files.
You appear on behalf of whom?
The temple, open up.
No, on behalf of
The party was appeared.
Subrat Satpathy.
Yes.
For Mr. Subrat Satpathy.
Yes, my lord, the office has failed. We will be appearing in filed by Wakalat Naman.
You mean so by one? We want to know.
Anand Chandra.
This is fine.
This is fine.
It is submitted that Mr. A.C. Swai and associates have entered appearance on behalf of OP number 2 by filing their Vinava. The name on
Today.
on today morning. Their office to verify and reflect their name in the cause list. Mrs. Parding in person. List on 24th April.
Item 33.
And you come with the affidavit.
My lord, may I pray and indulge my lords? On the last occasion, on 22/1/25, notice was issued only to opposite party number 2. I feel, my lord, if the opposite party number 1, which is government and law department, if they have.
You see, if the chief administrator, basically chief administrator has to take this step. So if they require any assistance from the government.
I think they are answerable to the cause which you have now raised. So let them come and show them.
You file the affidavit.
Item number 33.
Is it noting that notice and respondent number 21 has returned answer because of insufficient access? I pray that I will file the requisites by Monday.
You will take fresh notice.
Yes.
Mr. Rothal and counsel for the appellant 6 to take fresh notice on respondent number 311.
No, 311 is waiting.
On whom?
On 21. The next.
On 21, yes.
21.
On respondent number 21.
Requisites by Monday.
Issue notice to respondent, issue press notice to respondent number 21 by registered post / speed post and also through process.
Earlier was only
21 private party.
Private.
You also take by process. Through process, stock requisites shall be filed within 7 days.
1 month.
Within 3 working days.
And so far as
all right. Next, so far as the notice on 3/11/22/23.
24,
25, 28, 29, 30, and 31 are concerned. Responding number such and such are concerned. Notice is treated sufficient on them as per the office note and postal tracking report.
Okay.
Next list on 16th May.
Item 34.
The petitioners are telling
How can you prevent a bank from shifting? Oh, what is your right? Tell me. Can you impose something?
they have
They have raised lot of issues that during the rainy seasons there is a flood and that nobody can reach to a branch Secondly, they say that there is a power disconnection for months.
14 years in the bank.
Whatever, can you, that is what I'm saying. You must have a right under the Constitution. Tell me that what right, or under the Banking Regulation Act, because they are governed by that act. Is there any right which is created in petitioner? How can you maintain this? And now think the last time, if I correctly remember, you said that we have already taken the policy decision to keep one agency there for the purpose of deposits and money. What about the safe vaults? What about these lockers or the safe vault?
That has not been shifted because they are opposing that agitating the.
So now what to do about that?
My lord, the police prosecution may or guide them not to oppose, my lord, so that we can.
How can they oppose? They can't oppose. They have no right.
Because I have filed my lord.
It is the police administration who have to take action. Why you are not taking action? After all, they are dealing with the public money.
Separately.
So.
The version may dispose of the return.
It has to be. You do not have. Huh? Where is your affidavit which you say that the franchisee or something you have?
Second affidavit, my lord.
Affidavit?
My F, my flag E, my lord.
Flag E.
Yes, sir. Para 5.
Yes, you have said that you have
4 and 5.
No. You said that you have appointed some, yes, business corresponding agent.
Yes, ma'am. 4 and 5.
5 what?
5 is what the BC point will do, my lord.
Huh?
What the BC point will do, the banking services for the villages, my lord.
Okay.
What are the facilities available for the villages, my lord?
So 24 benefits of the amenities, facilities, he is entrusted to do that. The petitioner espousing the cause of the inhabitants of the village where the branch of the respondent was operating for a considerable period of time, and because of the compelling circumstances, the conscious decision was taken to shift the said branch to another place. To prevent such shifting, as it would cause greater inconvenience to the villagers. The public interest litigation is taken out, flagging such issue, and the orders were passed by the predecessors in disclosing the stand and the reasonable steps having taken to redress the grievance so raised by the petitioner. The second additional affidavit filed by the bank discloses the alternative arrangement having made for seamless rendering of services to its customers, except for the locker facility. You can't provide a locker facility. In order to appreciate the stand taken by the bank the excerpt from the second additional affidavit is quoted as under, quote paragraph 4 and 5. 6, 4, 5, 6. 6, yes. 6. Look, the primary object of the facilities provided by the bank has been succinctly jotted down in paragraph 5, which we do not find that any inconvenience would be caused if the branch is shifted, as the business, what is the full term? Business correspondent point opened by the bank would cater all such need. It is highlighted in the said affidavit that during the rainy seasons, the employees of the bank face difficulty in reaching to the branch, and even at times the power supply is disrupted for days together, affecting the banking activities. Full stop. We do not find any right having created into the villager, either under the Constitution of India or under the Banking Regulation Act, to prevent the bank from shifting its branch. And therefore, in stricto sensu, the grievance raised in the instant writ petition does not warrant to be redressed, since the PIR was entertained by the predecessor and the direction was passed, and the second affidavit revealed efficacious alternative arrangements having made by the bank. We do not think that any further relief can be granted to the petitioner, and therefore the writ petition is thus disposed of, to be treated as dismissed. Yes.
In IFRC, sitting of the board, my lord.
Disposed of.
For the IF file, my lord, because the sitting of the board, the state may be directed.
That you can't in his. That you'll have to take recourse. That you take recourse. How can double jeopardy? Yes.
Item note 35.
Item delivered.
3. You are for 3.
What about?
Mr. Mr. Das appears for OP number 3 and files his Nama in court. The same is kept on record.
Which time to file now?
You'll file the count. What is your stand? It is this government stand.
They have raised grievance.
Honest. List further, Mr. Das seeks time to file his reply. List on 8th May.
Item 36.
So let the matter listed with 19693/24, when which interim order will pass, saying the allotment is favor. License is favor.
Yes.
That is subject matter.
You have prayed for
That is
vacation.
how-
You have prayed for vacation in that IA.
Vacation has been filed.
In that case, they have filed vacation of interim order filed by
Collector
some
and
orders.
excise-
Except my allotment, it has been stayed by filed by other teachers, but state has filed vacation
So
of
that, so you want to connect it. All right, Mr. Kaur, Land and Government Advocate.
May I be permitted? I am appealing for the private opposite party and the license. I have been granted license. I have deposited the 3 months consideration amount and the.
We are taking up on next week, sir.
No, what I beg to submit, your lordship has by means of an interim order directed the OSPC not to issue any material to me. So may I pray your lordship, because I have the house, I am occupying I was having a running shop. So let me continue the
Because there is a stay, he has
Yes.
filed a vacation.
No,
of
that
fraud.
I am not concerned with that. My case, my full
He does not have any license lordship for this year.
Next week.
What I beg you, lordship, kind. Let me submit. Let me continue the shop without prejudice to the rights and contents of the petitioner. Because your lordship may kindly imagine, I have been deprived of continuing my business. Although lakhs of rupees I have
By
invested.
hearing both the matters.
Lordship.
Mr. Kaur, Land and Government Advocate, prays that this matter may be listed along with WPC.
19693/24.
List accordingly on 16th April.
Perhaps 2 week applications they have to have.
37.
Perhaps 2 week application.
Yeah, good. One is there. 136 only.
Interim order continue.
What is the interim order?
Interim lordship.
I'm restricted from lifting the materials.
Interim order they are lordship.
Interim order dated such and such shall continue till next.
Grateful lordship.
Item number 37.
Last occasion, lordship had this matter. Notice was issued. The counter has not been filed by the opposite party.
Who has to file counter? State.
State and the private opposite party.
Will file counter, Mr. Kaur?
One will go ahead.
Mr. Kaur, 6 time and GS 6 time to file counter. List on 29th April.
Item 38.
Case of real matter, the residents of the Trishul area were seeking a this court about the basis amenities.
Why you are not cleaning this? I think the corporation, it comes under the corporation.
No,
Municipal corporation? No, it does not come.
no, that is a
Area partly come under my CMC and most of the other areas come under the Baranga.
But they wanted their grievance is the proper maintenance or clearance of the drainage and the sewerage system. So why, these are the basic amenities, that's your responsibility.
I have today I have got the report regarding the areas where coming with the Gram Panchayat and we are coming in the CMC.
Correct.
So accordingly, I will file an affidavit and will see that if everything is ensured on.
It's not matter of Gram Panchayat or municipality. See, we are the citizens of India.
No.
You are not, you are citizen of.
You are absolutely. No doubt, but.
11 villages come under CMC and the rest of the villages comes to the Gram Panchayat. Panchayat service management.
You have to, this is a basic amenities. You can't undermine it, you can't avoid it.
So some part CMC has to do. So I have
We
taken.
will ensure that everything is done before the rainy season starts.
Yes, madam.
Because Mr. Kaur, Land and GA.
Island water is there, madam. And no drinking
As soon as
water.
let them file the affidavit, why in a hurry? Mr. Kaur, it's time to file affidavit for the state opposite party. List on 25th April.
39.
Sort it. You have to prepare the affidavit. You can prepare the affidavit so in a short period.
But because if here when the what who has to provide the water.
When you can file the affidavit?
2
weeks.
39.
Madam, I see a lot of letter.
26th March 2025.
Your Lordship,
Wherein
I have a preliminary objection that your Lordship kindly look into the last state's order, paragraph 2.
Last date order.
Your Lordship.
What is the, where is the last date order?
26th March
2025. My Lord is directed to file.
Where is the order? It's not uploaded.
If this case will be adjudicated, then it may be discrimination to yesterday's case. It is 2021 adjudication order.
Sorry.
Page 18.
1 minute.
Okay.
Paragraph 3 months.
In that regard, we have passed the judgment.
Yes.
Oh, this leave to file an additional affidavit.
But if he has filed the additional affidavit, what the respectful submission at paragraph 2 of the last state's order.
Has he filed?
Yes, I have already filed.
Have you been served?
Yes, I have already solved the copy also.
Where? He says
On
no.
7th, I have solved.
That's
I have filed online.
Yesterday in identical circumstances, your Lordship 2023 order has not been adjudicated.
correct. Correct. That is the submission which was recorded on 2. So yesterday we have already decided.
Here
It is really a covered
yesterday
under that.
2023 order.
Yeah.
Here 2021 order. March
So
page
we have
18.
already dictated one. You go through that order.
No, that copy has not been uploaded.
So just we are adjourning it for 15. Mean that in the meantime it will be uploaded. Go through that.
Let it common.
Section 169 interpretation and the common portal.
The same argument I have.
Yes, please go through that judgment.
My Lord, here the issue of
We are still open. Don't worry. We are still open. If you can convince us that we were wrong in that, we are open to correct ourselves. Don't worry. Come on.
paragraph 3 and 4 of the order, my kindly.
Please, I have seen. Yesterday, the judgment is dictated.
Go through the yesterday's order.
Yesterday item 20.
Please go through that.
Yes.
For hearing item 42.
42.
42.
Item number 42. The first item, government appeal number 36 of 2001. I'm for the respondent, sir. And in criminal appeal number 155 of 2000 for the
What is this GA? Okay.
Who is this to the from the state? From the state in item 42.
Mr. Sahu. Who is appearing? Oh, you are for the respondent.
in government appeal number 36 of 2001. And in the connected item, your lordship, criminal appeal number 155.
Mr. G. Tripathi, his name. Yes. Correct. Where is that? I understand, sir. And you have filed an appeal for acquittal. So both are to be tagged together and here. It has been tagged. So you wanted to argue.
Your lordship, I have a small grievance, your lordship. The exhibits which were produced before the learned trial court are not available with me. I may be allowed to take the soft copy of the exhibits from the court.
Paper book is ready. You have not been given the paper book.
No, your lordship.
Paper book has not been supplied to you.
No, your lordship. All the exhibits are not with me.
No, the paper book must contain the exhibits.
No, your lordship. Paper book has not.
Paper book is ready.
It's not.
Paper book
He is ready.
7 days. 7.
Where do I get it?
You have given this copy of the paper book?
I have not given one.
Two separate sets of paper book may be served at the council on the state council as well as Mr.
S. Sahu, Your Lordship.
S. Sahu appearing for the verdict.
Your Lordship.
List on. When you will come prepared? This is 2001 appeal, sir. You are not ready for criminal matter. List on 29 April.
Item 43.
All right, non-appeals on hold for the appellant. Then 25th April, Friday.